Yes, Mr. Chairman.
May I please, your lordship? I beg to mention for listing an urgent writ petition for tomorrow, my lord. What happened in this case? My lord.
Bench 3.
Bench 3 matter.
May it please, your lordship. Lordship, with the due consent of the other side, I beg to mention item number 34 of today's, my lord, daily list, lordship. Here, my lord, we have received our paravise comments, my lord. We'll be filing our affidavit, my lord.
On the prayer of Mr. A. Foucault, learned counsel for the petitioner, the matter stands adjourned for 2 weeks to facilitate filing of an affidavit by the respondents. Prayer is not objected to by the learned counsel for the petitioner. Also, accordingly, registry to list this matter again after 2 weeks on a date to be fixed.
May I please, your lordship? Lordship,
Keep
I
your
would like to mention item number 20 for adjournment, your lordship, of daily list.
Yes, why?
Your lordship, my senior KK Mohanta has recently undergone cataract surgery.
Prayer is made on behalf of Mr. KK Mohanta, learned senior counsel, for an adjournment in the matter on the ground that he is indisposed. Also, prayer accepted, registry to list this matter again after 3 weeks on a date.
Obliged, your lordship.
May I please, your lordship? I am paying for listing one bench three matter on Friday, lordship. Obliged, lordship.
May it please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 43, your lordship. Lordship, my senior, Mr. J. Chutia, is down with fever and cold.
Who?
So, Mr. J. Chutia, lordship.
Have you informed the petitioner?
Yes, your lordship.
Prayer is made on behalf of Mr. J. Chotia, learned standing counsel KAC, for an adjournment in the matter on the ground that he is indisposed. Prayer is stated to be made with the consent of the petitioner, learned counsel for the petition. Accordingly, registry to list this matter again after the ensuing summer vacation.
A date may be fixed.
On 15/7/2026.
Highly.
Obliged, your lordship.
May I please, your lordship? I pray for listing a repetition, my lordship.
What is when?
Any date, my lordship.
Bench 2, 3.
3 events.
So similar prayer lordship listing of a writ petition on 18th, your lordship.
Bench 3.
Bench, your lordship.
Yes.
Kindly withdraw this matter with liberty.
Yes.
Kindly withdraw this matter with liberty.
Why?
So at the time of filing the petition, some mistake are there.
Miss,
With us.
you are there in the case? Ms. Vidas, learned counsel for the petitioner, submits that she be permitted to withdraw the present writ petition inasmuch as certain errors. In fact, in recording of facts, what errors have come?
Some error, like some mistake are there.
What sort of mistake? You have missed out some facts. You have a typographical error. What is it?
Typing it.
Huh?
Typing it.
Typographical error. Amidst that, certain inadvertent typographical errors have entered into the present writ petition. And accordingly, the same, she prays for liberty to file the writ petition afresh after rectifying the said errors. Prayer accepted. The present writ petition stands dismissed on withdrawal with liberty as prayed.
I love this.
Lordship, kindly matter with time being, lordship.
None appears with parties on call. Registry to list this matter again after the ensuing summer vacations. Matter be not treated as parted and or tied up matter with
May it please, your lordship. Basically, what has happened, lordship, during training, he,
But you have done it in a very perfunctory manner. Where is the show cause? Not only training, you have also alleged some misconduct against him. Indisciplined conduct.
indiscipline,
Stealing.
yes, the stealing of one.
But where is the notice?
The notice has to be there.
No notice is here. Show me.
Otherwise, lordship, one more thing, lordship.
Hmm.
The proper procedure as per the DP rules are not required to be followed, I think, in this.
Why? You think you have alleged malafide against him? You have alleged misconduct, theft, and the tribunal has ignored that matter, that aspect of the matter.
That, lordship, it has been mentioned.
The impugned order is at page 25.
That, yes.
Unauthorized absence, so-and-so, indisciplined conduct as intimated by so-and-so, so-and-so, I'm satisfied, so-and-so. And how can you use, where is the interest of the state involved here? Clause C of 311 being invoked. What is
Interest
the,
of state. No, it is
what
only
is-
a case of misunderstanding.
no, why are you invoking article, proviso to article 311 too?
Lordship,
So-and-so, so-and-so could not require so-and-so, indisciplined, unauthorized absence, terminated. What's this? You allege, you attach stigma to a person and you don't hold the proceeding.
That is true, lordship, because
May all of Bishop Matiba.
My lord, on the last occasion, your lordship directed to produce the record of the disciplinary proceeding.
Hmm.
Lord, I have informed them, my lord, it hasn't come yet.
There is no representation on behalf of the petitioner on call. Mr. S. Dr. Learned Senior Counsel appears for the respondent bank. The doctor submits that the records in the matter has not been received and accordingly submits that the matter be taken up after the ensuing vacations. Also, prayer accepted, accordingly registered to list this matter again on 16/7/2026.
Obliged.
The next date of listing, the bank respondent shall produce the original records pertaining to the departmental proceedings instituted against the petition.
Obliged.
So, not what is your grievance here?
My grievance is that, my lord, I have been transferred in public interest. And my
Okay, show me the order.
page 32. In the interest on 14 November 2017,
Where is your posting in the additional chief engineer's
Yes.
office?
from there I have been posted to the
Where is that order?
joining report at page 22.
20?
On 22, 2017, joining report. With reference to the subject stated above, I have the honor to submit here with joining report of the following incumbent. We have Chairman Office of the undersigned for your kind
Come to page 20.
20. Yes, 20, this is the upgradation of the postage. I am directed to convey the sanction of the government to the creation of the Office of the Additional.
So, we have two rules, directorate rules and the ministerial district establishment.
District establishment.
Till the passing of this order, you were in the district establishment.
Yes,
It is with passing of this order that your services have been upgraded to the directorate. That also entailed a holding of a higher post
yes.
because it is with a higher salary. The grade pay is higher in directorate level compared to district level. So your entry for all purpose, intent and purpose in a directorate level post will be this Where is the seniority list now published?
Seniority list published, I have challenged this page 35.
Not 39,
Page
38.
35. Page 35, the seniority list.
Now, your name is
My
at serial number
50
59.
15.
Now, here it is clearly written that you were upgraded from the district level to directorate level.
Yes.
By so and so.
Yes.
Now, once you have come to a new cadre, how can you claim seniority therein over the persons who have been working in that cadre?
Seniority, because I was the posting holding the same designated post.
No, you were holding a post lower in status in the district level.
No, that is not the lower. My humble submission is the designation is same.
Designation doesn't
another
make
mail-
it.
another
Show me
ma-
a decision.
Yes,
that-
decision. Salary is not the only criteria.
No, salary is not the only criteria. You have come to a different service.
So when the my 14-year service will be,
That 14-year service
12 years
would have been, would
40
have been there, provided you continued in a district level establishment.
yes, my
Not in a,
now when I have been joined there, immediately I have been assigned the same duty of those who are performing. On the duty responsibility, education and qualification, there is no distinguishing character. Otherwise, I would not
no,
have been.
there is a change of service. You have been upgraded to a new service. Now, the persons who are there in the new service, how can you be placed senior above them?
So
Some services manuals.
there is no rules that the criteria of fixation of seniority.
Directorate level post is one for the state.
I was at that time drawing the because by virtue of my seniority, drawing the similar page.
You were in a district service.
Yes.
Show me, okay. What is show me a decision that you come
Decision
into a new
first of all,
service,
my lord,
upgradation of your service.
yes.
The earlier period has to be continued.
There is a decision in public interest transfer, my seniority.
Public
That,
interest
that,
transfer.
I am one by one coming.
That I forget, I don't.
I am coming to the my lord, judgment of the
The
SI.
subsequent public interest transfer.
Yes, SI Ruplal, K. Madhavan.
Ruplal.
Yes. Ruplal has, my lord, the
That is deputation absorption.
Yes, that is criteria of there, my lord, page 18, para 18. Sorry, para 17, 18 and 20. Para 70. In law, it is necessary that if in previous service of a transferred official is to be counted seniority. In the transferred post, then the two posts should be equivalent. One of the objection raised by the respondent in this case.
You were not transferred to the directorate service. You were upgraded to the directorate service.
I have transferred.
Where?
Two posts upgraded. Two posts of the.
So you were not upgraded in 2017 to this page 20. Your services was not upgraded.
No, I was I am showing them. Not upgraded. I was not upgraded. Let them show any order that is I have upgraded. I have just joined.
What is this order then, page 20?
UD assistant. I have the honor to submit the joining report of the following incomes we have joined.
2020. So you were upgraded by page 20.
One post upgraded to the superintendent. And one post remained the UDA.
UDA, you come to Mr. Nath. Please come to page 20.
20?
Huh.
Page 20, I am reading.
You have seen?
Yes.
What is that post?
Following
PA.
post of the existing office of the superintendent and PWD Karimganj BRC Circle Karimganj are hereby upgraded for newly created additional posts.
Hmm.
Superintendent UDA district level to the superintendent directorate level, one post UDA district level to the directorate level.
UDA directorate level.
Directorate level.
Now, district level post and directorate level post, are they the same? Is it the same service?
Not same service.
Is it the same rules?
Not same service.
So
Rule-
you
there
got,
is-
you
there is-
came into the directorate service. As far as directorate service is concerned,
Yes.
you came there after this upgradation.
Yes.
So then you were transferred from the directorate level post to another directorate level post. That is
Then
immaterial.
distinguishing criteria of the two posts, equivalency, that I shown in the SI reply. Judgment. Salary is not the criteria only.
It is two different service.
Different, there is deputation is from
That
different.
is a different concept altogether. You were not here on deputation.
No, these different services. When amalgamation pays the different services, then how this
There is no amalgamation here.
there is a deputation. My is upgradation. Deputation post is higher. That is why the salary is not only the criteria. SI reply, low late. Then my lord, Madhavan's case also, seniority and promotion. There is a CBI from
That is
CBI.
referred to in Ruplal.
Ruplal, Madhavan's. Madhavan's I am realizing para 1827. Para 18 and 27. There are also similar issues, my lord, different services. My 12-year service seniority, I will never be promoted.
Can't help it.
Policy decision cannot debar my promotion, man. Seniority also.
Not a policy decision. It's a.
Because upgradation, lordship.
You should have remained in the district cadre.
Sir, no, that is why public interest have been transferred. And when I joined, immediately I've been assigned the same duty.
Transferred not from district establishment to directorate. Directorate to directorate transfer.
That is, for first of all, upgraded, post upgraded.
Person also upgraded. You joined.
Yes, no, upgraded, post upgraded. When post upgrade is not a promotion, upgradation is not a promotion.
You have not been promoted here.
Yes, upgradation is not a promotion, post is upgraded.
Yes, Mr. Hawk.
My lord, our affidavit para 9. Affidavit filed by the chief engineer, my lord. Para 9. I'm reading for the second para. Additionally, the deponent begs to state that all officials working in the office of the superintendent engineer, PWD Karimganj, BRC Circle, Karimganj were upgraded from district cadre to heads of the department cadre on upgradation of the office of the additional chief engineer, Barak. So, my lord, basically, it was initially it was superintendent engineer's office, my lord. It was upgraded to chief engineer, my lord. And from district level, my lord, he has gone to so additional chief engineer, my lord, he comes in the ambit of chief engineer's office, that is directorate level office, my lord. The same is true for the petitioner as well, as since his post was upgraded from district cadre to heads of department cadre. Hence, the claim of the petitioner for promotion to the post of superintendent in the heads of department cadre is totally unfounded, as he had been newly included in the said cadre and as such was placed below the junior most senior assistant of the heads of the department cadre as per the prevailing administrative norms, which has been elucidated in the earlier, my lord, that is there. Moreover, it is also pertinent to highlight the fact that the upgradation of the petitioner to the post of senior assistant directorate level had earned him financial upgradation in the form of grade pay increase 2,400 UDA district level to 3,100 UDA directorate level. Hence, the petitioner has not been deprived of any benefits as claimed by him, and therefore there has been no discrimination against him. So, my lord, there is a, my lord, he did not lose, my lord. He got some financial benefit with the upgradation, my lord. Now para 10, my lord, how that chronological thing, how, my lord, his service, my lord, evolved, my lord. That with regards to the affidavit made in para 19, the answering department begs to state that the chronological order of the service of the petitioner is as follows. Initially appointed as peon in the district level, on 13/1/89, after which he was subsequently promoted to the same cadre to LDA district level on 4/2/92, and thereafter to the post of UDA district level on 4/5/2005. All throughout, my lord, he was in district level, my lord. With the upgradation of the office, my lord, he was brought to.
But Mr. S.
My lord, another.
I'm not disposing it off. I'm just taking down the facts. I'll also apply my mind.
Yes.
Heard Mr. S. Nath, learned counsel for the petition. Also heard Mr. R. Jha, learned standing counsel, public works department. Also, the petitioner in the present writ petition has assailed the seniority position assigned to him in the seniority list of senior assistants. In the seniority list of senior assistants working in the amalgamated establishment of the chief engineer, PWD roads and other officers as on 14/11/2017. The petitioner has further prayed for a direction upon the respondent authorities to assign to him his appropriate seniority position in the said cadre, in the cadre of senior assistant of the amalgamated establishment of the chief engineer, PWD, by reckoning the services rendered by him as UDA in the establishment of the superintendent where?
May Superintendent Kathak.
Superintendent engineer, the establishment of the superintending engineer, PWD, Karimganj, PRC circle. Also, as projected in the petition, the petitioner was initially appointed on 13/1/89 as a lower division assistant and had joined in such capacity in the establishment of the superintending engineer, PWD, BRC circle, Karimganj. That is the that is the one. So thereafter, the petitioner was promoted to the post of senior assistant, cadre of senior assistant, and he had assumed the charge of the promotion on 4/5/2025. So the petitioner projects that the respondent authorities provide a communication dated 6/2/2017 proceeded to upgrade the existing establishment of the superintending engineer, PWD, Karimganj BRC circle, along with the staff, proceeded to upgrade the existing office of superintending engineer so-and-so to that of additional chief engineer, PWD, Barak Valley. Also, the post of UDA held by the petitioner, one of the posts of UDA figuring in the establishment of the superintending engineer, PWD, was upgraded to the level to that of superintendent (directorate level), while the other post of UDA was retained in the same cadre, but in the was upgraded to the directorate level. In pursuance to the said upgradation of the establishment of the superintending engineer, PWD, Karimganj PRC circle, which also included the upgradation of the employees working therein, the petitioner joined against his upgraded post in the directorate level establishment on 20/2/2017. Also, the post of UDA held by the petitioner as created in the directorate level was subsequently was subsequently normalized by the respondent authorities. Also, in the list of employees working in the newly created establishment of the additional chief engineer, PWRD, Barak Valley, the name of the petitioner figures against the cadre of UDA assistant, bracket senior assistant. Also, the additional chief engineer, PWD, Barak Valley, filed a communication dated 15/3/2017, intimated the chief engineer, PWD roads, that although two posts of UDA were upgraded, why the communication dated 6/2/2017, one of the two posts was upgraded to that of superintendent bracketed directorate level, and the other post was upgraded to UDA directorate level. However, the services of the incumbents holding the post were not upgraded. Also, in view of the above position, the service particulars of the incumbents whose services were held to have been not upgraded, including the petitioner hearing, came to be so forwarded. It was highlighted that the salary bills of the existing staff were pending since 2017. Also, accordingly, it was requested that the budget be provided for the financial year 2017-18, including the area salaries with effect from 2017, and issuing necessary instruction for upgradation of services of existing staff like UDA/LDA. Also, the petitioner thereafter also submitted representations for upgradation of his services. Also, the petitioner void his representation dated 24/3/2017, highlighted before the additional chief engineer, PWRD Barak Valley, that two posts of UDA figuring in the district level cadre, figuring in the establishment of the superintendent of PWD, prior to the upgradation of the said establishment on, pursuant to the creation of the establishment of the additional chief engineer, PWD, one of the said posts was upgraded to that of superintendent, and the other post was continued as UDA. The petitioner projected that as the upgraded post of superintendent was lying vacant, and he was allowed to hold the charge of the said post, the petitioner prayed that he be posted as superintendent, considering his service length as an UDA. The pay of the petitioner not being released after upgradation, the additional chief engineer, PWD, white communication dated 22/8/2017, placed the said matter before the chief engineer, PWRD, and requested to pass necessary modification order for the post of UDA or to upgrade the petitioner to the post of superintendent as against the vacant post available in the establishment and for release of his arrears salaries. The additional chief engineer PWD again via communication dated 17/10/2017 approached the Public Works Roads Department approached the government in the Public Works Road Department requesting submitting a proposal for upgradation of the post of senior assistant to superintendent and highlighting therein that the post which has been upgraded as superintendent was earlier held by the petitioner. Accordingly, it was requested that the petitioner be considered for promotion, for appointment against the, for attachment against the post of superintendent. So it is in the above, it is in the above background that the petitioner was transferred and posted in the office to the office of the Chief Engineer PWD R Assam, Gauhati. In the said order, the petitioner was designated as Senior Assistant (UDA) in the office of the Additional Chief Engineer PWRD Barak Valley. The petitioner, on being released by the Additional Chief Engineer PWRD Barak Valley, joined against his transferred post in the establishment of the Chief Engineer PWDR. So, as the petitioner was so continuing in the establishment of the Chief Engineer PWRD, a gradation list of incumbents working in the amalgamated establishment of the Chief Engineer PWD Roads came to be published, and therein the name of the petitioner was so placed at serial number 59 by reckoning that the petitioner was upgraded to the directorate level post from a district level post only wide communication dated 6/2/2017. So being aggrieved by the seniority position as assigned to him in the said seniority list, the petitioner has instituted the present writ. Mr. S. Nath, learned counsel for the petitioner, by referring to the facts noticed herein, by reiterating the facts noticed herein above, has submitted that the petitioner being working as a UDA since the date of his promotion, that is with effect from 4/5/2025, albeit in the 2005, albeit in the district establishment, that is the establishment of the superintendent, superintending engineer, superintending engineer PWD Karimganj, is the upgrade on upgradation of the post held by him to that of the directorate level on the creation of the establishment of the additional chief engineer PWRD Barak Valley, he continued to discharge a similar nature of duties. Mr. Nath submits that the post of the establishment of superintending engineer being upgraded along with the post and the staff therein to that of upgraded, and the establishment of the additional chief engineer PWRD Barak Valley being so created, the staff on their such upgradation would be permitted to carry the seniority by reckoning the length service rendered by them in the post that they had so held at the time of upgradation of their services. It is submitted that the petitioner, having held the post of UDA since 2005, his seniority in this connection, seniority on his promotion, on his on upgradation of his services to that of UDA. To that of UDA, upgradation of his services and placement in the directorate level post in the establishment of the additional chief engineer PWRD Barak Valley is to be assigned with effect from 4/5/2005. He submits that the services rendered by the petitioner with effect from 4/5/2005 till the date of his upgradation cannot be wiped away. Also, Mr. Nath submits that the upgradation of the services of the petitioner cannot be deemed to be a promotion, requiring the fixation of his seniority on with effect from the date of such promotion. He submits that the upgradation is akin to that of a deputation, and accordingly, the period that a deputation accordingly, the deputation is being permitted to reckon the period of service rendered by him in his parent department for fixation of seniority in the deputed department, comma, the petitioner accordingly shall also be required to be permitted to reckon his seniority in the establishment of the superintending engineer PWD PRC Circle Karimganj bracket district level establishment bracket over, while assigning his seniority in the establishment, in the amalgamated establishment of the chief engineer, PWRD. So in support of his submissions, Mr. Nath has referred to the decision, has relied upon the decision of the Honorable Supreme Court in the case of K. Madhavan and another versus Union of India and others, reported in 1987. 4 SCC Upper Silvi 566 and SI Ruplal and another versus Lieutenant Governor Delhi, reported in 2001 SCC 644. Also, in the above premises, Mr. Nath submits that the impugned tradition list would mandate an interference with a further direction on the respondent authorities to assign seniority position of to the petitioner by reckoning the day he started. The day he had assumed the charge of the post of UDA in the establishment on promotion in the establishment of the superintending engineer PWD bracket PWD Barak Road Circle Karimganj. That much only. Anything more? Per contra, Mr. R. Learned Counsel for the respondent submits that the petitioner during the period he was so posted in the establishment of the superintending engineer Barak Valley, Barak Road Circle, Karimganj, was holding a post in the district establishment, and his services were covered by the provisions of the Assam Ministerial District Establishment Service Rules 1967. Mr. Dhar submits that on the upgradation of the establishment of the superintending engineer to that of an additional chief engineer PWRD, Barak Valley, the establishment now came within the amalgamated establishment, came within the purview of the amalgamated establishment of the chief engineer public works roads department. He submits that accordingly the services he further submits that with the upgradation of the establishment of the superintending engineer public ki BRC to that of additional chief engineer, the services of the incumbents holding posts on regular basis in the establishment of the superintending engineer PWD PRC circle also came to be so upgraded. He submits that on the upgradation being so effective, the services of the incumbents so upgraded would be now covered by the would be now covered by the provisions of the Assam Directorate Establishment, bracket ministerial, bracket over, service rules 1973. He submits that there be two distinct services existing, one at the district level, one that of the district level, and the another of the directorate level, comma. He submits that on the upgradation of the services and placement of an incumbent from who was erstwhile working in the district establishment in a directorate establishment, his seniority in the directorate establishment shall only be permitted to be so reckoned from the date he had assumed charge and or his post was so upgraded to that, upgraded from that of the district level to that of the directorate level. So accordingly, Mr. Hawk submits that the petitioner's services having been upgraded only with effect from 6/12/2017, comma, his seniority in the amalgamated establishment of the chief engineer, PWD, comma, against the cadre of senior assistant was so assigned, and he was so assigned by reckoning the date of his upgradation, and he was accordingly assigned the seniority position at serial number 59 in the said gradation, in the impugned gradation list. Mr. Dhot submits that in view of the above actual position existing in the matter, the petitioner, for the purpose of assignment of his seniority in the directorate establishment, cannot be permitted to reckon the services rendered by him in a district level establishment prior to his upgradation to that of a directorate level. Also, in view of the above submissions, in the above premises, Mr. Dhar submits that the claims made by the petitioner, present with petition, shall not mandate an acceptance. Also, I have heard the Learned Council. Okay. Heard the Learned Council for the parties at some length. Hearing remains inconclusive. Registry to list this matter again on 18/6/2026 for further hearing.
My lord.
Let me apply my mind.
My lord, only one thing, my lord. He did not lose out anything in financially.
Oh, he lost out everything. He would have been a head assistant in the superintendent's office if he continued as a, but now I'm
In the district level, my lord.
not convinced with his arguments, but let me,
All right, fine. 18/6.
I could not apply my mind yesterday.
I'm
Hey.
sorry, my lord, item number 5, I could not, both of we would not, my lord, appear in time, my lord.
After vacations.
My lord, lordship, a fixed date, since your lordship has heard in length.
No, I have not heard anything. I've released it. Eto yak video, a passport board.
Non-appearance may be deleted, my lord.
As prayed for by the Learned Council for the parties, registry to list this matter again after the ensuing summer vacations. Also, registry to list this matter on 16/7/2026. Baki last to thagibo.
Problem, problem.
Yes, Ms. Chaudhary.
Maybe not sure. But if the matter relates to a disciplinary proceeding and an imposition of a major penalty on the petitioner, I am challenging the proceeding on basically two grounds. Number one is non-examination of material witnesses and almost like a double jeopardy, Your Lordships. If I may be allowed to just place the facts before Your Lordships.
Just a moment.
Yes. What has happened in the matter, Your Lordships, is that they have charged me with something, let's say X, and what they have proved is Y. And I have always been saying that X is correct. And yet they are imposing the penalty on me after proving Y. I will just briefly indicate the facts, Your Lordships. If Your Lordship will kindly turn to page 22 of the writ petition. This is the memorandum of charges. Article 1, if I may be allowed to read. on the basis of the movement order number so-and-so dated so-and-so, CISC unit DHEP Doyang was sent on temporary duty to take part in the debate competition on the subject of human rights held in CISF NES headquarters, Kolkata. During the said temporary duty, he stayed in the transit camp of CISF NES headquarters, Kolkata. Now, you'll also will kindly note, he stayed in the transit camp of CISF from 29/6/2017 to 3/7/2017. But in his TADA claim, he submitted a false bill of staying in Madhuri House Hotel from 29/6 to 3/7/2017. The said bill.
Period is 29/6.
No, the dates are the correct. The dates are correct. The location is what I'm on, your lordships. Now they are saying that I have stayed in the transit camp at CISF NES headquarters, Kolkata. But I have submitted a false bill saying that I stayed in Madhuri House and I gave an extra bill of allegedly 4,000 rupees. That was the amount, your lordships. The dates are the same. The said bill with regard to his stay in the said hotel enclosed with his TADA claim form was sent to CISF NES headquarters, Kolkata for verification via letter number 28/8/2017 of CISF unit DHEP Doyang. And in reply to that, the CISF NES headquarters via letter number so-and-so informed that during the said temporary duty, he stayed in the transit camp of CISF NES headquarters, Kolkata, and on receipt of the payment of rupees 1,000 with regard to the stay, bill number so-and-so was issued by the transit camp. Thus, it becomes clear that he submitted a fake bill with his TADA claim with an immoral intention of receiving payment of higher amount. Now, they are themselves saying that I have stayed in the transit camp. This is the charge. And that supposedly, allegedly, I have submitted a fake bill of Madhuri Hotel. Now, your lordships will also come to charge number 4.
2.
Lordships 2 and 3 are other charges similar to that I have, that he was,
All this
I
have
have
been held to
stolen
be
the
proved.
bill.
All this have been held to be proved.
Yes, all of them have been held to be proved.
So
Yes.
let's see 2.
Let's, your lordships. Number so-and-so, Pradeep Balhara was deputed in NIPCO powerhouse duty in second shift from so-and-so to so-and-so on 29/2017. Now, this is after I've come back. During the said duty, he asked the unit in charge for relieving him from duty on the pretext of his illness. Subsequently to relieving him from duty, he was sent to doctor of NIPCO hospital with so-and-so, but his behavior near the doctor was not proper and therefore the doctor scolded him. Thereafter, he came to the main office of the unit, asked to show him his TADA bill, whereupon so-and-so Motilal gave him the TADA bill to see, but during that time, he took the TADA bill away from the information of which he was given to the unit in charge by the concerned clerk. Thereafter, the unit in charge called him and questioned him with regard to the incident, but he told that he did not take the bill away. Said act on his part shows his gross misconduct and indiscipline, which is never expected from disciplined member of force, hence the charge. Article 3, so-and-so influenced Constable Motilal serving in account section by asking him, it should have been him, to state in his statement that Pradeep Balhara did not come to the office of the unit. Said act on his part shows his gross misconduct and indiscipline, which is never expected from discipline for so-and-so. And finally, charge number 4. During his short span of service, CIS unit so-and-so Doyang has already been punished with censure twice by different disciplinary authorities for indiscipline and negligence as shown below. And thus he was given the opportunity to mend his ways, but despite that he has failed to rectify himself. Now they have noted these incidents where I was given the punishment of censure.
That article number 4 would
Lordships.
come into being if article 1, 2 and 3 are established. That is only for the purpose of quantum of punishment.
But your lordships, in my respectful submission, Article 4 cannot be a separate charge in itself.
No, there are decisions of the Supreme
There
Court
are
which says that
Yes.
this is just only thing.
Only-
I have also held in many cases that I have found cases where one say like 4 charges.
Lordships.
Fourth is a past misconduct. This is past misconduct.
Past misconduct. would
So
not
they
count
what they
under
have
the
done,
double
1,
jeopardy,
2,
your
3,
lordships.
nothing is there. But
Yes.
because of 4, they have punished, imposed penalty. I said nothing doing. This is only
This is
2.
not the case. They have said that 1, 2 and 3 are proved and hence
4 by itself is of
they are
no
also
use.
relying on 4. Yes.
That is of no use. The disciplinary authority can only take into account 4
Lordships.
past misconduct because he has to inform you
Correct.
either in the memorandum of charge or in the second show cause notice. That I also propose to take your past misconduct into notice while imposing the penalty. So this is there, forget it. But what about 1, 2, and
Lordships. Now, if I may take,
interesting?
Lordships, if I take your Lordships to page
Inquiry.
T4. Yes.
Ah.
This is PW3.
PW3 is
One Mr. Bipin Ekka.
now where is the material with regard to article of charge number 1?
Lordship, so what has happened is that they have relied on 9 witnesses, and of those 9 witnesses, everyone is saying almost the same thing, except for the fact that I have always, during the entire inquiry, I have maintained that I stayed in the transit camp.
No technicalities involved, cross-examination not granted, performance.
Allowed. No cross. They did not even tell me that I am entitled to have defense witnesses. The most important thing was that charge number 3, if your lordship had just noted, was about the, charge number 2 was about the doctor. And they did not even examine the doctor. The doctor was never examined.
The doctor, but if
Charge
you go
number
to
2. Yes. Now,
that doctor is a incident. It's a fact.
it's a fact.
But the incident is your taking away the TADA.
Taking away the TADA. Now, taking away the TADA also, they should have examined certain people. That I'm just coming to that, your lordships.
Where is Motilal's examination here?
The most important witnesses.
Motilal has been examined?
Yes, Motilal has been examined.
What is his statement?
Page 46, your lordships. Number 5, summary of the statement of so-and-so Motilal. As per the statement number so-and-so Motilal, he has been serving in this unit since 10/4/2017. And presently he is serving in the account section of the unit office. At about 16:30 hours on so-and-so date, Pradeep Balhara came to the unit office, and while saying that he was suffering from piles and he had to go to local NIPCO hospital for taking injection, requested head clerk Amit Kumar for arranging the help of someone in this act, whereupon Amit Kumar asked him to accompany him. When both of them went to the hospital, they found the hospital closed, and thereafter they proceeded towards the office. But Pradeep Balhara stopped near the bank on the way, and he came back to the office. About 5 minutes later, he came to him in the office and asked him whether his temporary duty bills were prepared or not, whereupon he replied in the affirmative. Having heard the same, Pradeep Balhara asked him to show the same. With permission of head clerk Amit Kumar, he showed the TADA register, wherein there were 2 TADA claims, one for Numaligarh tour and the other for Kolkata tour, and the Numaligarh bill was passed. Now, interestingly, I have never even traveled to Numaligarh, and they have passed this bill of mine, allegedly. I have never even submitted this bill. The TADA for Kolkata was not prepared. Then the charged official asked why the bill for Kolkata tour was not prepared and asked him to show the same. He, Motilal, took the permission of head clerk to show the TADA claim form related to Kolkata tour, opened the concerned file and showed him, whereupon the charged official opened the form at the top and started reading the same. The charged official was standing and moved to the chair lying nearby to read the paper sitting on the chair. Once, instead of sitting on the chair, he went outside in haste. He immediately informed head clerk Amit Kumar that so-and-so has left with the TADA form of his Kolkata temporary duty, whereupon all the persons present in the office, Motilal, etc., Mohammad Fareed and Harkesh Jatab and others, went up to the main gate of the unit office, but it was dark outside and the charged official was not seen. He then went towards the quarter guard and asked the sentry whether he had seen any person coming downwards, whereupon the sentry replied in the negative, but said that someone went upwards in a run from the gate of the office. He immediately went to the office barrack in a run, but Pradeep Balhara was not seen there. He asked the persons present there whether they had seen so-and-so, but Padam Singh and others told him they had not seen him there. Thereafter, he came back to the unit office and with the suggestion of Amit Kumar tried to inform the unit in charge of the incident over phone, but could not connect over phone. Thereafter, at about 1700 hours, Amit Kumar gave him the information over his phone. The unit in charge directed K. Banerjee, in charge of crime and intelligence, to go to SO's barrack with so-and-so and so-and-so and bring Pradeep Balhara therefrom. Thereafter, at about 7:30 hours, both of them brought Pradeep Balhara to the unit office and he started interrogating the charge official with regard to the incident. During the interrogation, so-and-so came out of the chamber of the unit in charge and requested him in such terms: I am a Jat and you are a Rajput. Please tell that Pradeep Balhara did not come to the office keeping my children in view. Now, during the cross-examination by the charged official, Motilal made it clear that when Pradeep Balhara came to the main office, he, that is the charge official, was not in a position to walk and therefore he asked for help. Now, this is important, Your Lordships. When he came out of the main gate of the office with Mr. Balhara, the latter, the charged official, started walking like a normal person and his condition outside was not like condition inside. During his statement, he made it clear that the Numaligarh TADA bills he had mentioned actually was of Dibrugarh, which was entered in serial number so-and-so in the TADA register, which he submitted as Exhibit 1. So now, who is at fault? The Dibrugarh bills have been submitted as Numaligarh bills and they have been passed by Mr. Motilal as and submitted as Exhibit 1 and have been taken on record by the inquiry officer.
You have the
Then-
records with you?
Yes, Lordship.
Find out Exhibit 1 from that. Yes.
In reply to the question put by the presenting officer, he replied that he accompanied the charged official to NIPCO hospital, which is situated about 100 meters away on foot. And it seemed to him that the charged official was not suffering from any such disease and that he was walking well. Now, if this was the case, immediately, as a lay person, what comes to mind? Who would have been the best person to clarify this situation? Whether I was falsifying my claim of having a piles pain or whether I was a normal person.
But the hospital was closed at that point of time.
The inquiry continued for several days, Your Lordship, and I have met the doctor. I have produced the slip of the doctor's, the doctor's examination slip, the certificate. I have produced it as a document. Then, now, if I may take your Lordships to page 53, which is PW9, one Mr. Amit Kumar. Now, one more thing, Your Lordships, in page 48, before going to 53, at page 48, the fourth line from the top, Your Lordships. The unit in charge, Lordships have got it. The unit in charge directed Mr. K. Banerjee, in charge of the crime and intelligence, to go to SO's barrack with SI so-and-so Rajneesh and so-and-so and bring Pradeep Balhara therefrom. Now,
You were in your barrack.
yes. Now, K. Banerjee was also never examined. So, now coming to PW9 at page 53, Your Lordships. Do I read the whole thing, Your Lordship? Should I
No,
just
no, forget it. You can come to the analysis
Sure.
of fact.
Got
Page 80.
in I will just read PW9 for just one line from the bottom, Your Lordships. Page 53, the line 1, 2, 3, 4, 5, 6, 7th line from the bottom, Your Lordships. Someone so-and-so in charge, Shri Kalyan Banerjee, sent the bills of TADA claim to CISF NES headquarters, Kolkata, for verification. But the verification report thereof has not been received in this office till date.
But your charge says something else.
Correct, Your Lordships. Now, page 55 again. When second line, Your Lordships, Kalyan Banerjee of the INT section was asked whether Pradeep Balhara had come to him, whereupon he replied that he did not. So there is a complete between the witnesses itself, Your Lordship, there is a complete this thing. Now, at page 56, this is the summary of the charged officer, Your Lordships. I may just read two lines, the second paragraph of page 56. Page 56, second paragraph, Your Lordships. In reply to the question, Lordships got it? In reply to the question put by the presenting officer, he stated he submitted his TADA claim form enclosing bills of transit camp SO's hostel in the unit office and that the allegation against him that he had enclosed the bill of Madri House is false. On 29, 2017, he was deputed in B shift. Blood came out with his stool from 3 or 4 times in between so-and-so to so-and-so. He informed the unit in charge of this, and as per the order of unit in charge, SR Meena relieved him of duty, and thereafter he went to the residence of the doctor with B make. The doctor gave him some tablets, suggested him to take rest, and take an injection immediately in the hospital. After visiting the doctor, he was going to the hospital at slow pace but he felt the urge to visit toilet, whereupon he went to the toilet of the office where he came across Mr. Motilal. The allegation that he influenced Motilal is false. He has accepted that he has already been punished by disciplinary authority. The charged officer has submitted the prescription of doctor as Exhibit 1, certificate of doctor as Exhibit 2. So he has submitted the prescription of the doctor as Exhibit 1 and the certificate of the doctor as Exhibit 2, the paper of treatment during leave as Exhibit 3, and the bill of Doyang medical source as Exhibit 4. What more did I need to do to prove that I was unwell?
Madam, one thing is also clear
Yes, Your Lordship.
from this depositions recording that you had cross-examined the witnesses and you had also produced defense documents.
No,
So
I
to-
did not use any defense witness, Your Lordship.
No, defense witness.
Defense witness was
Witness,
never.
that was for you. If you can produce documents, if you can produce witnesses. So now technicality gone. What we have to see is whether the charges leveled against you had any substance. If it had substance, whether it can be held to be proved because of the contradictions and the
Lordship,
statements.
perhaps not let the technicalities go so easily. I would like to submit before your Lordship.
Okay, where
that
is
there are
your
several
where is
witnesses-
your application made? I'm only on the technical part.
Lordship,
Where is your application made? Submission, you have submitted any application before the disciplinary authority or the inquiry officer? Say I've been deprived of this. Okay, fine, not in the inquiry. In the appeal you filed or against in the representation against the inquiry.
let me
officer.
just check my revision petition, Lordship. I think it was at page.
Revision is too
190.
distant a time.
No, Your Lordship,
There is an appeal in between.
No, in the CISF rules, it is called, is it called? No. Appeal under Rule 44 is at page 173, Your Lordships.
Now let us see the conclusion of the inquiry officer, page 80.
Lordships. 80, no? Analysis of the facts, Your Lordships. With regard to the disputed facts, it is a matter of discussion that in compliance with movement order so-and-so, went to CISF NAS headquarters to take part in the debate competition over the subject of human rights. And during his temporary duty, he stayed in the transit camp situated there from 29/6 to so-and-so. And that is exactly what I have been saying all along, that I have stayed in the transit camp and that that he submitted fake bills in Madhuri House. Now, I never submitted these bills. That has been my constant stand, and I have never signed on any of the documents which they have produced to prove that I am staying in Madhuri House, Your Lordships. During the cross-examination, Your Lordships are reading page 81.
Yes.
During the cross-examination by the presenting officer, Motilal, who is posted in the account section, stated that the charged official submitted his TADA claim form enclosing the hotel bill of so-and-so. During the cross-examination by the presenting officer, Bipin Eka, who works as the company writer, stated that self-attested hotel bill remained enclosed with the TADA claim form of charged official so-and-so. PW7, Assistant Commandant seeking information with regard to the stay of the charged official during his temporary stay in Kolkata from so-and-so, since the TADA bill submitted by the charged official was under suspicion in the unit. And in the reply letter, Kolkata gave the information that during the temporary duty, the charged official stayed in the transit camp situated in so-and-so. Then in the reply to the brief note of the presenting officer, the charged official stated that the allegation that he submitted the bill of Madhuri House Hotel for his stay on so-and-so is false and baseless, and that he enclosed the bill of transit camp with his TADA claim form. He also stated that the allegation that he stayed in Madhuri House, Kolkata for 5 days and procured bill thereof is false and baseless, and that no such evidence had been adduced during the inquiry. The charged official has also stated that the claim of PW9 and PW5 that the signature of the charged official appears in the bill of Madhuri House is false and baseless, and that PW9 and PW5 failed to prove that the charged official had submitted the bill of Madhuri House. On examination of the brief note of the presenting officer and the written statement of the charged official against the brief note, it appears that the charged official submitted the bill of Madhuri House, Kolkata, and his signature appears in the column of the consumer in the bill, which tallies with the signature of the charged official and PW9 and submitted so-and-so, respectively, proving that the charged official enclosed bill of Madhuri House, Kolkata with his TADA claim form. On the basis of letter number so-and-so, dated 7/2/2018 of the inquiry officer and letter number so-and-so of the senior commandant, got the bill of Madhuri House Hotel verified by Brajesh Kumar. Now, these two are were not listed as documents in the state documents
Was
to be
copy
relied upon.
given to you of that?
Not given to me, Your Lordships. Because they hadn't arrived, because there was one noting, if Your Lordship will remember, I had just read that verification is yet to come. That was the case. Now, if I may take Your Lordships to, so there's a whole lot of this thing. Main conclusion is at page number,
You can come to 90.
yes, Your Lordships.
Let's take
Findings
that.
of the inquiry. It has become clear from the statements of witnesses admitted and revealed facts analysis made in para 1 and the documents submitted by the prosecution and defense that as per movement order so and so, he was sent to CISF on temporary duty so and so. Hence, during the temporary duty, he stayed in the transit camp situated at CISF NES Kolkata from so and so, but he submitted bill of Madhuri House Hotel showing his stay in the hotel. Hence, the article of charge 1 framed against so and so stands proof from the statement of the prosecution witnesses and the statement of the charged official made in his defense and the document submitted by the PW and the charged official during the inquiry. How? I have always said that I have never stayed in Madhuri House. Next, it has become clear from the statements of the witnesses admitted and revealed facts, analysis made in para 2 and the document submitted by the prosecution and defense that on 29/2017, so-and-so CISF unit so-and-so remained deputed in the NIPCO powerhouse duty on second shift from 1300 hours to 1900 hours. During that time, he got relieved himself of his duties, taking the pretext of his illness, and after coming to the main office of the unit, took his TADA bill to see and took the same away without the permission of information of the competent officer. Hence, the article 2 framed against so-and-so stands proof from the statements of prosecution witnesses, statement of the charged official made in his defense on the document submitted by the PW. We also will again note that one of the witnesses has said that I never came to meet him only in the office. Whereas two of them are saying that yes, he came and he snatched away the bill only. Number 3, it has become clear from the statements of witnesses, analysis made in para 3 and the documents submitted by prosecution and defense that number 2 and so posted in the account section by telling him to state in his statement that Pradeep Balhara did not come to the office. Article 3 framed against so and so stands proof from the statements of the prosecution witnesses. Number 4, it has become clear from the statements of witnesses admitted and revealed facts, analysis made in para 4 and the documents submitted by the prosecution and defense that during his short tenure of service has already been awarded punishment twice by various disciplinary authority for his indiscipline and negligence and was given the chance to mend his way or rectify himself. But despite that, the charged official has failed to mend his way or rectify himself. Hence, the Article 4 also stands proof from the statements of conclusion.
Now, you were given a copy of this inquiry report and you
Yes,
submitted a representation.
Submitted my appeal.
Now, what
Then
is
the
the
revision,
final conclusion?
lots of the revision was also rejected. The revision order
The
is
punishment is at page 158.
158. Yes, Your Lordships. The order, of course, yes, Your Lordships. 158. Yes. The last paragraph, paragraph 8, CISF is an armed force of the union and exemplary conduct is expected from every member of the force, but the charged official has failed to do so. The act committed by the charged official shows as misconduct and indiscipline, which is never expected from a so-and-so. I, the undersigned, in exercise of powers conferred by Rule 32 of CISF Rules 2001, passed the order of punishment as per Rule 34(5) of CISF Rules against, in such terms, reduction of pay by 2 stages of rupees 41,000 to 38,700 in the pay matrix of 6 for a period of 2 years with immediate effect. It is further ordered that so-and-so will not earn increment of pay during the period of reduction and that on expiry of that period, the reduction will have the effect of postponing his future increment of pay.
So you submitted a appeal
Yes,
against
I
this.
submitted an appeal, rejected. Then I submitted a revision that was also rejected. And therefore, I am before your lordships. Now,
Where is the ground taken in your appeal or in your revision with regard to the technicalities?
lordships, just,
Prejudice costly.
yes, your lordship. Lordship, sadly, the writ petition was filed by other concerned councils, and my appeal has not been annexed to the writ petition. Perhaps a copy of that might be available in the records, your lordships. So I cannot directly address your lordship on that particular fact. However, if I may just be allowed to, revision petition is there, Asil, na? At page 171, your lordships, is my revision petition.
Thereafter, you have the appellate order.
Lordships?
Thereafter comes the appellate order.
No, the, in the petition. Lordships. sadly, what?
No, it's okay, it's okay. So it's
Yes.
there, that's enough.
Yes. Revision petition starts at page 170. The
Nothing is there with regard to any prejudice caused to you in the inquiry. It's all on merits.
Lordship's prejudice cause is the fact that the three witnesses were not examined. I have said,
Three witnesses whom you say are vital witnesses were not examined.
yes, your lordships.
But why did you not call them?
Lordships, that from what I have been instructed, your lordships, is that
You are at the rank of, you are a
sub-inspector, your lordships. No, constable name.
sub-inspector.
SI.
So you should know. You are trained.
Lordships, the fact remains that to prove an inquiry, and I have
Your
30
basic case,
decisions of
Chaudhary, is that
lordships,
with regard to the first charge,
lordships.
the inquiry, it had been come on record that the clarification from Kolkata was not received. So that charge
So-
cannot be held to be established.
Established. Number one.
Two,
Um,
with regard to the tearing of the DA bill or taking away the TADA bill,
there
the
are,
only evidence is of Motilal.
yes, and there are contradictory statements by other witnesses saying
Other-
that I would never even visited the office or whatever.
But your
But they have certainly relied upon
thirdly,
Motilal.
that your this medical ailment, there
Yes.
subsequently doctors have come in and you were given treatment and those documents have come on record.
Not subsequently, on the
Not when
same
that
day, your lordships.
Same
Yes.
day.
Huh.
That
Yes.
you were having hemorrhoids.
Yes.
So you were given an
Yes.
injection and
Correct.
all those have come on.
On the same day, I went
So
to treat
the
your lordship.
Motilal being influenced, that is a transaction which took place after he had been brought, he had taken the TADA bill away, allegation.
Allegation.
He had taken the TADA, then they were searching for him. He was found in his barrack
Yes,
by that Banerjee or somebody.
correct,
And he was brought.
right.
And it is at that time he is purportedly alleged to have asked or alleged to have tried to influence Motilal by saying that I'm a Rajput, I'm a Jat, you are a Rajput, don't do
No, your lordship, this was a little earlier.
earlier.
The allegation is that from the hospital, from that NIPCO hospital, I come directly to the office and I try and snatch the bill. That is the allegation. And I try to influence Mr. Motilal to say that I am a Jat, you are a Rajput. Please don't, say
Well, I'm
whatever,
in the office.
all of these things. And then I run away to my barracks. From there, I'm procured and brought back. That is the allegation. Now, your lordship, the interesting fact is that in the affidavit in opposition, if I may just take your lordships to page 7, paragraph 21. That with regard to the amendments made in paragraph 13 of the writ petition, the answering deponent begs to state that the petitioner had accepted that he stayed in the transit camp of CISF NES Kolkata with effect from so and so to so and so during temporary duty for debate competition. This is exactly what I've been saying, your lordships. And this is what your charge was, that I stayed in the transit camp. Now, it is evident from the statement of Amit Kumar, prosecution witness in short PW9, that the petitioner claimed TADA for temporary duty at Kolkata for his stay at Madhuri House, Kolkata. This has never been proved because I have never ever signed on any document, your lordships, whatever they have tried to produce in respect of Madhuri House. Further, in reply to question number 3, asked by the presenting officer, Constable Bipin Ekka, replied that the petitioner submitted hotel bill along with his TADA bill. Lordship will kindly skip the next part and come to the last line. Thus, it is clear from the corroborated deposition of PW3, 5 and 9 that the petitioner enclosed the hotel bill for staying at Madhuri House along with his TADA claim. The said receipt of bill of Madhuri House was also sent to CISF NES Kolkata for verification of its authenticity, and in response to the same, the CISF Kolkata wide letter dated 22/2/2018 intimated that the bill of Madhuri House was found correct. Further, the petitioner refused to put his signature on the above bill during the course of departmental inquiry. On the other hand, PW9 produced a copy of Madhuri House bill dated 3/7/2017 during the departmental inquiry in support of his statement that the petitioner submitted the above bill along with the TADA claim. The petitioner endorsed his signature on the same without raising any objection in presence of inquiry officer and PO and PW9. This is incorrect, Your Lordships. I have raised my objection several times. Thus, the petitioner accepted the submission of Madhuri House bill. No, I did not. Therefore, the plea of the petitioner is baseless and hence denied. Now, Your Lordship will kindly find the Madhuri House bill at page 15.
Writ petition.
Yeah, no. Affidavit in opposition, Your Lordships. I never got a copy of this. I have never even seen this in my life, and therefore, Your Lordship will find this is exhibited as the Exhibit 3, Annex to 1, and it is supposedly Pardeep Balhara. I do not know how this has been passed by the registry because it's not legible. But Your Lordship will kindly note at the bottom left-hand side corner, I have written refuse to sign. Bottom left-hand side corner, I have refused to sign. The charged officer has refused to sign this bill. And on the bill also, there is no this thing. It is just a bill. I can today make a bill saying that Pradeep Balhara stayed in Madhuri House and produce it. How is this verified? How has this bill been verified? And then Your Lordship will kindly come to page 17. Now, this is Mr. Brijesh Kumar, one of the witnesses, no? PW, no, not a witness. He was sent subsequently to verify, Your Lordships. Paragraph 2 at page 17. Page 17, paragraph 2. This is some verification report, Your Lordships, also exhibited as Exhibit 2. During the course of inquiry of the hotel bill and entry register, I have found that CISF number so-and-so has stayed at Hotel Madhuri House from so-and-so to so-and-so. That is 5 days and
Was
paid.
Brijesh Kumar a witness?
Brijesh Kumar was not a witness as because he was the deployed in crime and intelligence wings only, Lordship.
But
Of
he
say-
is saying something after an inquiry. It's in the form of, say, a preliminary inquiry. Now, if this report is to be accepted, because it goes to the root of the matter, then without examining him, how can his statement be accepted? Okay, we'll come to you.
There's no, and Lordships will find that it doesn't seem to have been, there's no date on this particular document. At least not in my copy, Your Lordships. I do not know if
So who produced this Brijesh Kumar statement, or it automatically came in the inquiry?
this has been given to me only now in the affidavit in
The
opposition.
inquiry, have they taken exhibit number 2? Who has produced exhibit number 2? Who has exhibited this?
I wouldn't.
It has come through the statement of which witness?
Lordships, let me just, charge is in my
Rup Singh Negi.
Yes, that's it.
We'll have to keep in view Rup Singh Negi's case. That if you are relying on some document,
Yes.
the author of that has to be also examined. Because this document cannot be cross-examined.
Sure.
Get my
Uh,
point, Ms. Barua?
Yes, Lordship.
Document cannot be
All
cross-examined.
exhibits too.
Cross-examination will be of the
Which one
person
is
who is producing the document. Let's check up who has produced exhibit.
41. Lordship, what they have done is that each prosecution witness, they have given different, same exhibit number. So PW5, exhibit 1, 2, 3, 4, 5. PW1, exhibit 1, 2, 3, 4, 5. So this exhibit 2 is of which witness is something I may not be able to tell you, Lordships. I apologize, Your Lordships. What's the answer? Page 41.
Ask your colleague, Ms. Chaudhary, ask your colleague to also go through the records
Lordships.
and mark the relevant portions wherein exhibit 2 was exhibited. Because this seems to be the only document connecting you and Madhuri.
Yes, Your Lordship. Now, you also will note that they have charged me that you have stayed in transit camp and they have proved the opposite, that I have stayed in Madhuri House.
What their charge is that I have understood. You actually stayed in Madhuri, in transit camp.
Transit camp,
But you produced a false bill claiming 4,000 TADA
correct.
by projecting that you had stayed during that period at Madhuri.
Madhuri House.
That is it.
Lordships.
And if this is
Your Lordship,
exhibit 2 is the only document, then it will be very serious.
Lordship will kindly find at page 38 and 39. These were the lists of exhibits. So there are, like, for example, there is a PW5 exhibit 2 at page 39 of the writ petition.
38, 39.
39. Yes, Your Lordship. This is a list of documents And at serial number 8, your lordships will find photocopy of the bill of Madhuri House. This is a photocopy of the bill, your lordships. This has been submitted by PW5 Exhibit 2. It could be this particular document. Now, I'm not sure. Or your lordships, uska marking kya tha, us wale ka? At serial number 22, page 41, your lordships.
Serial number 8 is photocopy of bill of Madhuri
Madhuri
House.
House. This was submitted by PW5
PW5
as Exhibit 2. Then your lordship will also find at serial number 14. This is also a photocopy of bill number 1902, which is the document of the affidavit in opposition, your lordships. Dated 3/7/2017 of Madhuri House Hotel, enclosed with TADA claim.
No,
for
this is
certificate.
different. Exhibit 3, this is, I think, Exhibit 2 is the one which they got from Calcutta.
Yes, your lordship.
And Exhibit 3 is the bill.
Yes, is the bill.
Which you,
No, no.
purportedly you annex to your allegation.
Yes, yes.
Well,
Correct,
right,
correct.
right.
Yes, yes.
Which
And
you
what they
annex
have?
to your,
Ah.
what do you call that? Bill.
TADA.
TADA bill.
Yes. And then serial number 22 is the verification report of hotel bills in respect of CIS so and so, Brijesh Kumar. This is document Exhibit 2,
No, what they have done is,
lordships. This was not exhibited by anyone, your lordships.
no, what they have
Either by the
done,
prosecution.
what they have done is,
Lordships.
the documents exhibited by each of the witnesses were numbered as 1 and 2, not in a running manner.
Not in a running. That's what I'm saying, your
So
lordship.
1 and 2, PW5, PW7 again 3 documents.
Yes, your
4,
lordships.
9 again Exhibit 3.
Exhibit
Okay.
3 is also there.
And which one are you referring to, page?
Serial number 22, page 41. This is the document which they have
Ah.
annexed in the
Ms.
affidavit of
Borua,
opposition. Yes.
how have you accepted this? Document number 2, Exhibit 2.
Yes,
DOC means document.
document.
Now, this seems to be not established or produced in the inquiry by any witness.
Brijesh Kumar is not.
Okay.
ये चीज वो बात-
Okay, we'll hear. Madam, yes, what do you have to say?
Lordships, perhaps I may be allowed to just produce 2 judgments I'm relying
Ah.
upon before my learned friend starts.
There are some judgment copies here also.
Lordships, 2016 4 GLT,
Just,
when your lordships were on this side. There, your lordships, I'll be relying on paragraph 52, 30, 30 and
Para?
52, your lordships.
Hmm.
And therein, your lordships would perhaps recall that the other judgment, Pratap Kaivarta, has also been
Hmm.
quoted, your lordships. So paragraph 30 and 32 of Pratap Kaivarta and Nabokanta Kalita, paragraph 52, your lordships. I would also rely on 48.
How
And
the, how does para 52 start with?
At this stage, reference
Okay,
may be made.
done.
And paragraph 48, your lordships, rule 36(3)(1) stipulates. This is with regard to the double jeopardy, which I was talking about, your lordships. The so here also, in this particular case also, your lordships, all the charge, the inquiry officer did not take into account the fact that one of the best persons to have examined would have been the person who had traveled with me in the for that entire what was it called, the event.
No,
Savan Kumar
See,
Khande,
they have got it on record,
lordships.
or enquiry report, a verification report, fine, no issue, they can do that. But mere production of that enquiry report will not tantamount, make it a legally admissible
Legally
evidence. There has to be, it has to be introduced by
By
some,
some witness, it
witness.
has to be introduced as
because that document,
correct.
the contents cannot be disputed by asking the document. You can dispute it only by
Only by
cross-examining the
Examining, yes.
witness. Yes, next one.
In paragraph 52, Your Lordships, of Navakanta Kolita, very categorically says that while the disciplinary authority, the appeal authority, and the revisional authority maintained a stoic silence in this regard, though this point was raised by the petitioner before each of the aforesaid authorities, and the counter affidavit respondents have taken the stand that the petitioner was free to call any witness to support his case, including so and so, but he did not do so. The plea at paragraph 53.
Your case will be covered by Hardwari.
Yes, it's
Vital
quoted.
witness.
It's quoted. Yes, Your Lordship. I will read paragraph 53.
No, it's okay.
It quoted
It's okay. It's okay.
there as well. So these are the two decisions that I'm relying upon, Your Lordship. And the fact that non-examination of these witnesses has materially affected my case, and introduction of subsequent facts by the authorities has naturally resulted in vitiating the proceedings. Your
So
Lordship.
you will also be relying on Rup Singh Negi,
Yes, Your Lordship. Definitely.
2009.
Lordships, may I also just point out one more rule before Your Lordships of the CISF rules 2001. I'm just producing a copy. Pagination kora ase na.
Now, the vital witness, according to you, are the persons who had proceeded with you for that training.
That event, number one. Secondly, the doctor. And thirdly, the ASI Kalyan Banerjee, who was entrusted with the responsibility of inquiring into the alleged submission of the false bills. पेज नंबर बोलो तो CISF rules का अभी मार्क किया था इसका निकाल.
Doctor of Nipco Hospital.
Yes, Your Lordships.
P.S. K. Banerjee.
Yes, ASI K Banerjee.
Who had brought you.
Yes, Your Lordships. And no, he was also entrusted with finding out the, at that stage, he was entrusted with the responsibility of forwarding and inquiring into the alleged submission of false bills. The statement is at paragraph 12 at page 9, Your Lordships, of my petition. And of course, the fact that they have relied upon a particular document, which is not even part of the inquiry proceedings.
What was that name, that man?
Motilal, Your Lordships?
No. Suresh, that person who went to Calcutta.
Oh, so, his name is Sawan Kumar Pandey. Oh, no, the Brijesh Kumar. Brijesh Kumar. Lordships, one more thing. If they were saying that I was the one who had submitted the TADA bill for Madhuri House, that ought to have had my signature on it. Because when you are submitting a claim, you're supposed to submit each thing with a signature. That was never the case, Your Lordships. They have submitted a photocopy of a bill which did not bear my sign. And therefore, during the inquiry also, when they tried to produce that exhibit 2, I did not sign. I have refused to sign on that particular document, Your Lordships, even during the inquiry. In paragraph 13 of my writ petition, I have said this as much, that the normal procedure for submission of any bill is that it has to be authenticated by the officer himself. So if that bill did not bear my sign, how did they take it on record? The fact that they have one mistake, which was glaringly evident in so far as Mr. Motilal was concerned, was that instead of Dibrugarh, he has said Numaligarh, and he has passed my bills, whereas I have never even been to Numaligarh. So it is entirely a possibility that Mr. Motilal might have been at fault, and I am being victimized for something which I have never even done. My consistent stand all through has been that I have stayed in the transit camp, and that I have never submitted any false TADA claims. That has been my consistent stand throughout the inquiry proceeding, Your Lordships. Just one last thing, Your Lordships. The CISF rules of 2001.
Hmm.
If Your Lordships will take up page 15, 15.
Yes, you
This
can
is-
tell me.
This is the procedure for imposing
Rule.
major penalties.
Rule?
Rule 36. This is the procedure for imposing major penalties.
Which is,
It's-
what do you want? to-
And I'm going to take Your Lordships to page number 19. So this is rule 36, within brackets 19, within brackets 1. That is 36(9)(1) of the CISF rules 2001.
Rule 36(9).
19,
19,
1. Small Roman 1.
Roman.
Yes.
What is there?
After conclusion of the inquiry, a report shall be prepared and it shall contain number 1, the article of charge and the statement of imputations, the defense of the enrolled member, an assessment of the evidence in respect of each article of charge, and the findings on each article of charge and reasons thereof. Explanation. If, in the opinion of the inquiring authority and the proceedings of the inquiry established that any article of charge is different from the original article of the charge, it may record its finding on such article of charge, which has also not been done in this particular case, Your Lordships. Provided that the findings on such article of charge shall not be recorded unless the enrolled member has either admitted the fact on which such article of charge is based or has had a reasonable opportunity of defending himself against such article of charge.
Yes, Ms. Barua.
Deeply obliged, Lordship.
Yes, Lordship, as per our instruction or affidavit we have filed, different respondent authority ample opportunity was given to the petitioner to whole.
No, we are not. There is no technicality involved here. I have told Ms. Chaudhary also.
Yes, Lordship.
But you come to the charges.
List of witness also provided to the.
We say that you have done it perfectly.
And
We hold it. We are not going into technicalities because the advocate cannot raise a technicality. Technicality has to be raised by the delinquent. But you come to the charge. See, we are not. We have the power to examine whether at least the evidences that have come on record, one, are admissible legal evidences. Two, whether these evidences connect the charges to the petitioner. That's all. That's all we can. Otherwise, it will be a case of no evidence. That much only we can. If it is there is some evidence, we should keep our hands off. That's the law. Now you come to article of charge number 1.
Charge 1. Yes, Lordship, the document exhibits 1.
So the original, according to you, is not there
Yes, Lordship.
because he has destroyed it,
Yes,
right? So you will be relying on a photocopy.
yes, Lordship.
Maybe the photocopy which you had utilized for sending to Delhi, Calcutta for verification.
Verification, Lordship.
Now, the main point here is that in that bill, the signature of the petitioner is not.
In customer's place, his
Signature is not there. So how did you accept it at first place?
customer here, there his signature is there, Lordship.
Where? Show me.
Signature is there, but it is not.
Something is there.
Yes, Lordship.
What is that page number?
The 9 exhibit 2. Page number 30, report. And in our affidavit also it is annexed, Lordship. Page 15. In customer, here it is signature is there. It is not in our affidavit. It is not visible, Lordship. Here it is also.
Now, that bill that was produced as exhibit PW 9 exhibit 3. Okay, fine. Now there is another exhibit 2.
Another.
PW5 exhibit 2. What is that?
PW. The report is also there, let's see.
Now this bills, which is a document exhibit 3, not produced through any witness. Oh, where, just a moment, where
All documents.
is the bill that he submitted produced as a exhibit?
Here is report. It is there.
Exhibit? Because he will submit a TADA bill, along with that, he will enclose that hotel bill. Where is that document? Okay, Ms. Barua, do one thing. You mark all this exhibits, relevant exhibits, with regard to article of charge number 1. Then the exhibits pertaining to article of charge number 2, and check up whether this serial number 21 to 26 in page 40 was introduced to some witness, or it was just taken on record, that much. Just make an index, the thing. I did not go through the whole thing. Just that index, the relevant statements with regard to that witness who had produced, what was the questions asked by the petitioner during cross. That much you can just make a note for me. How long will it take for you? 1 week?
1 week, let's say, before vacation, May.
Before vacation.
Yeah.
Ms. Chaudhary,
Your Lordships?
we give her an opportunity, let her come up with the documents.
Yes, Your Lordship. No doubt.
And ask your colleague also to go through the
If you
original
need,
file.
certainly,
Why Ms. Barua will allow, there is nothing confidential there.
if you have like.
Go in her presence, ask her,
Yes, Lord.
do it. And you also make a note for me.
On 16th, Your Lordships?
Kindly fix it on 23.
6, that I would have, in a series to. Miss, that there is a big series on that day.
24, Naiba.
Huh?
Lordships?
24,
23,
I also.
you're not there.
I am there, Lordship.
So
but
23, I have.
No,
seven
no,
parts.
please, whenever it's convenient.
Then 22nd, Your Lordships?
22nd, no problem.
22nd, I'll. on my left.
22nd.
Yes.
At the. Okay. I go. Next to material.
Lordships will keep it hot and
I've spent much time.
Yes, Your Lordships. Deeply obliged.
I only want to confirm
Yes.
whether
That
the
document
original
was.
is gone, whether the Xerox was duly and can be relied upon, and whether your bill had your signature, and therein, forget the photocopy of the hotel bill, the TADA bill, you will have to prepare that,
Yes, Your Lordship.
whether that had your signature. That much you got to find out. Then we will think what can be done. Otherwise, only on the basis of that Rajesh Kumar report, you can't hang her because he was never examined. Okay.
Deeply obliged.
Another thing, Ms. Borua, the person who made the inquiry in Calcutta,
Rajesh Kumar.
Rajesh Kumar, that is the person.
Yes, yes,
He gave the report.
yes.
Okay, let's see.
Deeply obliged.
Give me a note,
Yes.
small written submission.
May please your lordship, lordship standing council of animal husband and veterinary departments is not feeling well. Lordship kindly fix the matter at 2.
No, not today. She'll ask her not to come. We will have it some other day.
Kindly, Lordship, date may be fixed, Lordship.
I'll fix that. A prayer is made. Oh, I don't like it. But the learned counsel for the parties at some length, hearing remains in registry to discuss matters in on 22. 22/6. 6 Papa. Cannot Likibi. A prayer is made on behalf of Ms. M. Kotoki, on Standing Council, Animal Husbandry and Veterinary, for an adjournment in the matter on that sheet. Prayer accepted. The registry to list this matter again on 17/7/2026. I should not be seeing her. Let her get fully cured, then she'll be here. Tell her.
Well, but we could not reach some time.
Yes, where is Mr. Dotto?
Doctor was here, mother.
What is his instruction?
He has said me, my lord, there is an instruction, they want to file an affidavit on that.
Heard Mr. J. Pine, Learned Counsel for the petition. Can you get him?
Yes.
Ma'am, anything more to be added?
My lord, they have filed an affidavit again, my lord. In addition, government has filed an affidavit annexing that recent notification, my lord.
When?
Today itself, my lord, in the court I have received it.
Who, Ms. Bhattaji has filed?
Yeah. My lord, this notification actually, my lord, it was passed on 28th February 2024, my lord.
That will be for the future thing.
Yes,
Cannot-
my lord. And at that time, my lord, in their affidavit, previous affidavit, they did not mention about this, my lord.
Tell me, madam, one thing. Now you say that there ought to have been a written examination.
Yes, yes.
There
Should not have been. Yes.
There ought not to have been a written
Yes, yes,
examination.
yes.
The marks should have been given on the basis of the
Notification.
educational
Yes.
qualifications and an interview.
Yes,
These two.
yes,
But you with open eyes participated in that thing.
that's right.
But
That's
you
right.
never raised an objection. Now, after having participated, not qualified, now you are not permitted. How old are you now?
I'm 54, my lord.
Still within, if there
Yes.
is a selection, you can come in.
Yes, my lord, but the same thing will be repeated, my lord, because, my lord.
No,
your
if they have
lordship-
changed the norms by now, if there is a written examination introduced,
Yes,
we
my
will
lord.
not interfere with that. We will say that your case should be considered strictly in accordance with the procedure as now has been laid.
My lord, as per their rules also, my lord, Women and Child Development, the Directorate of Women and Child Development rules, my lord. There should have been, she should have been promoted, my lord, because 50% was there, my lord, from the experiences, my lord. So that's why this is
No,
25%.
because in the earlier round of selection, we will not bring that because you never questioned that, you participated. Now say you
That's
were
right.
selected, you will not have had this grievance. So we will not permit that. But the 24th thing, just give me the affidavit. The earlier part we will reject and the subsequent thing, we will direct them to any idea when they are going to hold the Mr. Dhar, who is your day?
Mr. Rahuldhar is here, Lordship, and he's coming, Lordship. Jolly fast. Ahile namok jolly ahibo লাগিব.
My lord, in their affidavit, my lord, previous affidavit, my lord, they have, my lord, categorically said, my lord, that 2012 guideline, as per that guidelines, we have conducted the selection,
But
my
the
lord.
only problem is, madam,
And now
if I
doing something
interfere,
else,
no,
my
if
lord.
I interfere with this, it's not only
But
the lady who is
can
there.
it be directed like this, my lord, to give her
I
a
can't do
promotion,
that.
my lord, in case a vacant post is there, my lord?
No, I
supervisor?
can't do that because I'll have to be, if
But
I
this-
interfere with this, I'll interfere with all the selections made under that. They are not before me. It will be causing, I'll be,
No, my lord, if there is any, my lord, post of, vacant post of supervisor, my lord, because as per her experience, my lord, she has been working
there
for
will be
more than
many others.
2
madam.
years, my lord.
There'll be many others in the fray who have
But
a similar.
Come, my lord, only I have
But
come, my
coming
lord.
or not
Only
coming,
I have come, my lord.
these poor
And
category
I'm aging
people,
also, my lord.
these poor people, they may not even know that they have a right. So somebody came up to you, madam, you advised her that you have a right.
Yes,
But
my
those
lord, yes.
people, they may not even know that. So if I pass an order, it would be, yes, Mr. Dhar, are you holding a selection?
My lord,
Are you holding a selection?
my lord, today we have filed an additional
You filed an
affidavit
affidavit, fine. What is that?
bringing out this is 24, my lord, notification,
New notification.
new
my lord.
notification by which actually we thought of filing a day for yesterday, we could not locate the council, my lord.
My lord, she is graduate also, my lord. For graduate Anganwadi worker, there is a specific consideration should have been, my lord. And she has experiences in computer, so that is also one of the criteria, my lord. There is no harm, my lord, if she is considered by the department, my lord. And she's, after 6 years, my lord, she'll be 60. A retiring, my lord, age, almost. So she may be considered, my lord, in case she joins also, my lord, she participates in, my lord, selection procedure, same thing may happen, my lord. There is no guarantee she'll be selected. As per your lordship wish, my lord, if she may be considered, maybe direction may be made, my lord. The consideration does not mean
When are
she'll
you,
be
where
selected.
this thing should be done on a regular basis. Now you're not doing it for a long time. Last one was 2012. Thereafter, I don't think so you have done it. 12 years, no consideration. Why?
Yes, my lord.
Mr. Dhar,
My lord,
12 years, no consideration. And 1st of January, of which the advertisement is issued. Have not even issued an advertisement till now. 12 years, no vacancy.
There are vacancies, my lord.
Because there may be many like and last time you made a error in holding a written examination because that was not provided in the rules. Now you have provided for that. Now you have provided. Your affidavit says that it will be the 2012, not the latest one.
now my lord, the thing is that she is overage.
What is there an age limit?
45.
Only those candidates on the date of their proposed appointment as so and so have not attained 60
This
years
60 years.
shall be considered. Okay. Madam, the
Maybe
earlier
this was
part,
the, my lord, as per law.
no, the earlier part, we are not interfering.
My lord.
Holding that you have participated in the selection process with open eyes. Only after that, following Madan Lal now, we are not interfering. Second part, your this prayer that now that they have done this, we direct them in the event there are vacancies available in the cadre of supervisor against 25% reserve quota.
Yes.
Steps be expeditiously taken to advertise the same in accordance with the notification dated 20/2/2024. Participate, conclude that within a particular time, and the petitioner will also be permitted to participate in that. And
But otherwise also she is legally, my lord, she is
entitled.
eligible to participate, my lord, since 60 years, my lord. But she will not be benefited, my lord.
That, madam,
That's for sure, my lord, that's for
I
sure.
cannot help it.
Because this has been lingered for so many years, my lord, this case, just to avoid her promotion, my lord. When government says something, one day something else and other day something else, completely different, my lord. They admitted in the previous affidavit, my lord. And also there is a cut-off mark, my lord, they have said.
You can file a writ petition assailing this notification guidelines, asking that there has to be a provision for experience.
Yes, my lord. But isn't it, my lord, they have made the illegality, my lord.
But you.
They say 12 notification has been followed, but
Madam,
they have not followed.
You
my
did not make a objection. You participated in the.
lord. That was a mistake because I'm a
Mistake
layman, my
means,
lord.
madam,
I'm a layman,
mistake
my lord.
means if you had succeeded, you would not have been here.
And that only, my lord.
Now, if I have to
Came to-
interfere it, if I have to interfere, I'll have to interfere with the 200 odd appointments made.
That I understood, my lord.
How will I do?
But,
Okay,
my lord-
this is what we do, ma'am. I have 2 orders to pass. Third order, I'll pass this second now. You need not be here, your colleague can be.
obliged, my lord.
Smile. Well, instruction is saying something else, man. Those discharge letters, they could not give yesterday, Your Lordship. Those, there mentioned some annexes, my lord, that on 2015, the petitioners were discharged.
Hmm.
Those documents at this stage, I don't have with me.
There was due orders passed discharging. them.
Yes, thereafter only they were discontinued.
When will I get those? When will you get those?
Lord, within 10 days, my lord, we will file affidavit, my lord. My lord.
Heard Mr. J. Pine, learned counsel for the petitioner. Also heard Mr. S. Dr. learned counsel, learned standing counsel, Panchayat and Rural. Mr. Dr. on instruction has received instructions to effect that the services of the petitioners were discharged in the year 2010 on account of low performance of work in implementation of MGNREA scheme. So, Mr. Dr. submits that he would bring on record the discharge orders of the petitioner along with the grounds on which they were so discharged by way of filing an affidavit on or before 17/6/2026.
Well,
The registry to list this matter for further hearing on 22/6/2026.
obliged. Highly obliged.
Lordship, can you allow for time being?
Registry to list this matters again after the ensuing some winter vacations, summer vacations on a date to be fixed. Right? Twice we called. Now,
She was here, Lordship.
There has been some changes, subsequent factual developments. What had happened in the connected criminal case, there was a conviction. And against that, there's a criminal appeal pending before this honorable court, which has been registered and numbered as criminal appeal number 304 of 2024. Therefore, my lord, at this stage, no relief can be granted. So what I would suggest, my lord, I would be withdrawing it with liberty to approach again, my lord.
Mr. A.K. Borua, learned counsel for the petitioner, submits on instruction that he be permitted to withdraw the present with liberty to approach this court, liberty to refile the same if the occasion so arises. So prayer is not objected to by Mr.
M.K. Das, Lordship.
M.K. Das, learned counsel for the respondents. Accordingly, the present petition stands dismissed on withdrawal with liberty as prayed for.
Right.
Deeply obliged.
Yes, Mr. Chaudhary, what are you waiting for? Well,
Yes, but the dismissal? Is for dismissal.
oh. Yes. What is something is there?
Lordship,
Nothing is there.
nothing is there, Lordship.
But Mr. D. Gugwe, learned counsel for the petitioner, also heard Mr. R.K.D. Chaudhary, learned senior counsel, and D.Y.S.G.I. assisted by Ms. L. Devi, learned counsel appearing for respondents number 1 and 2. Also heard Ms. U. Sharma, learned government advocate, appearing for the respondents number 3, 4, 5, 6, and 7. The petitioner in the present petition has sought for a direction upon the respondent authorities for appointing the petitioners in terms of their placement in the select list as published pursuant to the selection held in terms of an advertisement dated 13/6/2019. The chairman, State Level Police Recruitment Board, Assam, had issued an advertisement dated 13/6/2019, inviting applications for appoint engagement on contractual basis for 2 years in foreigners tribunals under the government of Assam. Various posts were so advertised. Also, the petitioners being eligible had submitted their respective applications for the posts involved, posts advertised via the advertisement. And it is projected that on conclusion of the advertisement, the petitioners were selected candidates against the post for which they had submitted their application. The select list is projected to have been published on when? Select list published?
19/9/2019.
On 19/9/2019. The appointments not being effected in respect of the petitioners hearings, they had approached the respondent authorities by way of filing representations. A response not being received from the respondent authorities, the petitioners had instituted the present writ petition, praying for a direction upon the respondent authorities for implementing the select list prepared in the matter. Also, Mr. D. Gogoi, learned counsel for the petition by reiterating the facts noticed herein above.
No, my lords. I'm not reiterating anything. I tried to contact these petitioners. There's no connection with them.
Reiterating the submissions made herein above, submits that the tribunals in question not being constituted, the new tribunals as contemplated, new foreigners tribunals as contemplated not being established, not being created, the select list as prepared in the matter in all probability was not given effect to. Also, Mr. RKD Chaudhary, learned senior counsel and DYSGI, submits that the submission made by the learned counsel for the petition that the tribunals, new tribunals for which the process of recruitment was initiated by the advertisement dated 13/6/2019, not having seen the light of the day, that is, they not having been created, the select list so prepared, there was no occasion for implementing the select list so prepared in the matter. He submits that the advertisement itself had stipulated that the select list would remain valid for appointment from the date of announcement of the result for a period of 1 year or till the date of next advertisement of similar post, whichever is earlier. He submits that the select list having been published on 19/9/2019, in terms of the stipulations made in the advertisement itself, the select list to the validity of the select list lapsed with effect from 18/9/2020. The petitioners is found to have approached this court after the validity of the said select list had lapsed in the matter. Also, I have heard the learned counsel for the parties and also perused the materials available on the portal. Also, as stated in the by the learned counsel for the parties, the recruitment in question was for establishment of 200 new foreigners tribunals in the state in view of the NRC updation works underway at the relevant point of time. Accordingly, for ensuring smooth running of the tribunals that were being contemplated to be created, the advertisement dated 13/6/2019 for the ministerial post that would now be created in such that would now be required in such newly created tribunals, foreigners tribunals, came to be made to equity. Also, however, it is seen that the 200 tribunals as contemplated was not created in view of the fact that the NRC updation works had not reached its conclusion. Also, accordingly, the respondent authorities had not proceeded to implement the select list prepared in the matter in pursuance to the advertisement dated 13/6/2019. Also, further, this court notices that the said select list having been published on 19/9/2019, in terms of the stipulations made in the advertisement, the said select list had lost its validity after lapse of 1 year from the date of its publication. Also, accordingly, the tribunals not having been set up, the respondent authorities, there was no occasion for the respondent authorities to effect appointments from the select list. So accordingly, for the said reasons, this court holds that the no right of the petitioners in the matter came to be infringed. It is a settled position of law that mere placement in the select list would not mandate that such person should also be appointed, and the appointment would and the implementation of the select list would involve various factors which is required to be considered by the employer. The petitioners in the present writ petition having not alleged any mala fide against the employer and also not having alleged that the select list was being implemented without considering the merit position of the candidates placed therein. This court is of the considered view that the claim made by the petitioners in the present writ petition would not mandate an acceptance. Accordingly, the present writ petition is held to be devoid of any merit, and the same consequently stands dismissed. However, there would be no order as to.
Observations.
May it please your lordship. Matter relates to compassionate appointment, your lordship. Lordship, they have filed an affidavit by the respondent authorities, your lordship. In the affidavit, your lordship, at page number 9, your lordship, of the affidavit, there is a direction by the then deputy commissioner to place the case of the petitioner before the appropriate district level committee. Page 9 of the affidavit in opposition. The then deputy commissioner directed that the matter be placed before the DLC for a decision, your lordship. In pursuant to that, your lordship, this honorable court, lordship, will find the order 18/10/2023 directed the authority to inform as to what happened, whether the case has been considered.
18/10/23.
23. That was the latest, your lordship. If it has already been considered, your lordship, they may.
Any further submission?
So my prayer, your lordship, if they have already considered.
They have considered, they have not considered.
No,
There is
the
no-
outcome should be communicated, your lordship, and if not considered, at least a consideration must.
I'm closing this.
The
But
lordship will close, but with the direction, your lordship. It is not a case, your
After
lordship.
2012, in 22, after 10 years, what is the compassion left? He might have passed that order. It's not binding on this court.
No, that is correct, your lordship, but he has immediately approached, your lordship. It is the authorities who have not taken a decision.
You, at 12, did you approach in 2012?
Paragraph 6 में
I have
कहीं
annexed the document, your lordship.
Para 6 of?
Para 6 of the affidavit in opposition that we have filed, lordship, on behalf of respondent number 2. No petition was submitted. Later on, lordship, her son approached, lordship.
Lordship will kindly see page 18 of my writ petition, your lordship. Now they are denying that I have not filed. your
Fine,
lordship.
these are disputed questions. We're not going to.
No, Lordship, at least a consideration by the DLC is
I'm
required.
sorry.
And in fact, the Deputy Commissioner himself has
I'm sorry.
admitted that the matter be filed before
After
the
12
DLC.
years, 13, 14 years now, there cannot be a consideration.
Now, if they have already considered, your Lordship,
If they have already considered,
outcome may be
they are not
communicated.
appointed, that will lapse.
But if they have not considered, at least a
But
consideration. is
I
required.
can't direct it. I'll not direct.
It was submitted in 2021, Lordship.
Page 18 is there, your Lordship. Page 18 of my writ petition. I have annexed the petition that I have submitted, but they are now disowning it.
Okay.
Since it is the Deputy Commissioner, he himself stated that the matter may be
You
placed, your Lordship.
you proceed against him, ask for damages, no problem. But this matter, we are not continuing any further. But Mr. M.H. Lascott, Learned Counsel for the petition. Also heard Ms. S. M. Bachaji, Learned Additional Senior Government hearing for the state respondents. The petitioner by way of instituting the present petition has prayed for a direction upon the respondent authorities for consideration of his case for appointment on compassionate grounds by placing his application before the jurisdictional district level committee. Also, the father of the petitioner, Abdul Karim Barbhia, while working as a chainman, CHA, in the establishment of the settlement officer Haila Kandi, died in harness on 14/12/2012. Also, it is projected that the mother of the petitioner on 2/1/2013 submitted an application before the respondent number 2, that is the Deputy Commissioner Hailakandi, to the Assistant Settlement Officer Hailakandi, that is the respondent number 3, praying for consideration of a case of her eldest son, that is the petitioner hearing, for appointment on compassionate grounds. Also, also, compassionate grounds. Also, after submission of the said application, it is projected in the petition that the petitioner was pursuing the matter with the respondent authorities. So no application in this matter has been brought on record. Submitted in the matter has been brought on. So the petitioner only projects that he was under the expectation that the district level committee would consider his case in accordance with the policy in vogue at the relevant point of time for appointment on compassionate grounds. So the respondents have been not considered the case of the petitioner for appointment on compassionate grounds. The petitioner had instituted present writ petition on 1/9/2021. Also, I have heard, Professor, Mr. Lascott, M.S. Lascott, Learned Counsel for the petitioner. Reiterating the facts, by reiterating the facts noticed herein above, has submitted that the respondents having formulated a policy for appointment on compassionate grounds and therein having required the consideration of the case of the applicants initially by the district level committee and thereafter by the state level committee, comma, the petitioners, the application submitted in respect of the petitioner ought not to have been ignored, and the same was required to be placed before the designated, before the jurisdictional district level committee, and thereafter basing on the recommendation of the committee, further steps as was mandated in the matter was required to be taken. By referring to the affidavit filed in the matter by the respondents, comma, Mr. Oscar has submitted that the Deputy Commissioner Hailakandi, wide communication date 18/1/20, had directed had written the application submitted by the petitioner for appointment on compassionate grounds to the Senior Assistant Settlement Officer Hailakandi with a request to place the same before the next district level committee meeting for taking appropriate decision. So, Ms. Bhattacharjee, on the other hand, has submitted that the contention of the petitioner that an application in the matter was an application seeking compassionate appointment in his case was submitted by his mother on 2/1/2013 is not found to be correct in as much as the said application is not found to be in records of the respondents. He submits that considering the long lapse of time occasioning in the matter, comma, no direction is called upon to be put for a consideration of the case of the petitioner or appointment on compassionate. Ms. Bhattacharjee has referred to the application issued by the Senior Assistant Settlement Officer Hailakandi on 7/1/2022, wherein it was highlighted that no application was dated 2/1/2013 and other documents were received from the mother of the petitioner for appointment of the petitioner on compassionate grounds. It is further highlighted that such application was only received on 2/9/2021. Also, it is submitted that the communication dated 18/1/2022 by the Deputy Commissioner Hailakandi was in response to said communication dated 7/1/2020 issued by the Senior Assistant Settlement Officer Hailakandi. He accordingly submits that it not been established that petitioner had submitted an application for petitioner on his own motion or on his behalf. An application was submitted for appointment for consideration of his case for appointment compassionate ground proximate to the time of death of his father, comma, the delayed submission of application by the petitioner would have the effect of rejecting his case for such consideration, for such consideration. So I've heard the learned counsel for the parties and peruse the materials available on it. The father of the petitioner, a government servant, while discharging his services, had died in harness on 14/12/2012. It is projected by the petitioner in the writ petition that his mother had on 2/1/2013 submitted an application before the Deputy Commissioner Hailakandi through the Assistant Settlement Officer Hailakandi, praying for consideration of the case of a son, that is the petitioner, for appointment on compassionate grounds. The receipt of the said application is disputed by the respondents by way of filing an affidavit in the present petition. In the said affidavit, a communication dated 7/1/2022 issued by the Senior Assistant Settlement Officer Hailakandi is brought on record. A perusal of the said affidavit would reveal that it was projected therein that the petition purportedly, a petition dated 12/2/1/2013 filed by the mother of the petitioner was never received in the office of the Senior Assistant Settlement Officer. It was further projected that the application for consideration of the case of the petitioner for appointment was received only on 2/9/2021. Also, accordingly, it is seen that the submission of application for consideration of the case of the petitioner approximate to the time of death of his father is disputed. The application is admitted to have been submitted for such consideration by the petitioner only on 2/9/21. Also, the petitioner on the date of death of his father was a major. Accordingly, the submission of the application on 2/9/2021 for consideration of his case for appointment on compassionate grounds in the considered view of this court is in clear violation of the policy of the procedure laid down in the policy in vogue at the relevant point of time for effecting appointments for consideration of cases of the applicants for appointment on compassionate. Also, accordingly, this court does not find any error to have been committed by the respondent authorities in not placing a non-existent application of the petitioner before the jurisdictional district level committee. The subsequent application dated 2/9/2021 submitted by the petitioner being a delayed application would not mandate a consideration on merits. Also, having drawn the said conclusion, this court is of the considered view that the claim made by the petitioner in the present writ petition for direction upon the respondent authorities to place his application dated 2/1/2013 before the jurisdictional district scrutiny committee would not mandate an acceptance from this court. Also, having drawn the said conclusions, this court would now further examine the claim made by the petitioner for a direction upon the respondent authorities for a fresh consideration case for appointment on compassionate. As noticed herein above, the father of the petitioner had died in harness on 14/12/2012. More than 14 years is found to have lapsed since the date of death of father. Also, although it is projected that the petitioners had submitted that an application was submitted on behalf of the petitioner 2/1/2000 for his appointment on compassionate grounds, this court, as noticed herein above, has found that there is no material brought on record to demonstrate as to the manner in which the petitioner and or his family members had pursued the said application. Also, the petitioner is found to have not diligently pursued his case for appointment on compassionate. Accordingly, on account of the lapse of around 14 years since date of death of the father, we consider immediacy required to be followed in respect of compassionate cost insofar as the case of the petitioner. The claim of the petitioner is rendered stay. Accordingly, this court would not be permissible for this court to issue a mandamus basing on such claims which have already been rendered stay. Also, in view of the above discussion, This court is of the considered view that the claims made by the petitioner in the present writ petition are mandate as acceptance, and accordingly the writ petition is held to be devoid of any merit, and the same consequently stands dismissed. However, there would be no. Sorry, Mr. Joseph.
Obliged, Lordship.
Yes, Doctor. Standing Counsel, Revenue and Disaster.
Obliged.
This is something which I have been consistent.
Yes, yes.
And I will not change.
The moment I saw the case listed before this honorable court, I was knowing the meeting. I made.
It's not that. It's a principle on the basis of law I
Yes,
have
yes.
taken.
Otherwise,
It was tested before the division bench.
Yes.
It maintained. So I should not.
My lord, may I
Please, Lordship. Item number 19 for admission. Today they have filed, government has filed the affidavit. May I please to fixed on after
19,
16, my lord,
16.
16th of July. Sorry,
19, Lordship.
19. Today is the file.
Mr. Paul, R.C. Paul, learned counsel for the petitioner, submits that an affidavit on behalf of the respondents has been respondent.
Yes,
Yes, respondent 1 and 5.
Respondent number 1 and 5 has been filed today. He prays that he be granted 3 weeks time to file a rejoinder thereto. Pray accepted, registry to list this matter again after 3 weeks on a date to be fixed.
16th of
And
July.
I'll pass the order in the second half.
My lord, item number 1, when it will
I'm
be
passing
called?
in at 2 o'clock.
my lord, may I please, your lordship, I'm waiting.
My lord,
No, I normally follow that, ma'am. I first complete the top of the list matter, then I pass the orders.
my lord,
1, 2, 41, 3.
my lord,
3 orders. Then.
my lord, that may be fixed on 16, my lord. 16th of July, my lord.
My lord, may I beg to mention item number 30, my lord? I have
3-0.
30, my lord. In this case, my lord, affidavit is required, my lord. We will file affidavit within a week, my lord.
On the prayer of Ms. N. Pukan,
Kindly, madam,
registry
let me
to list
speak
this
the
matter.
next week.
Appearing for the respondents, registry to list this matter again on when?
After a week, my lord.
On 19/6/2025.
Fine.
19/6.
Deeply.
Item number 14, we were directed to produce Lordship original record.
Hmm.
And Lordship, by our mistake, Lordship, instead of Lordship, in our data.
40.
114, Lordship. Petitioner is also there, Lordship. Instead of mentioning the date, today's date, we have mentioned in our letter 19, Lordship, and we have called for the record for 15th.
On the, we have, when should I fix it?
And on 19th, we have mentioned, Lordship, in our letter.
On the prayer of the learned council for the respondents, registry to list this matter again on 22. 22.
Lordship.
19 you are getting it.
Yeah, by 19, we have asked. Lordship.
22
20.
for 6/2026 to facilitate production of the records as directed by the earlier order.
Can it be on 23rd?
23, no.
Lordship.
Always.
Obliged.
But if I don't get the records on the next
Yes.
day, we will be in trouble.
Lordship. Obliged, Lordship.
42, my lord. That matter, my lord, was pleased to take up yesterday, my lord. I was not present. My lord. My lord, may I pray for a short accommodation on next Tuesday, my lord?
Why?
My lord, some difficulty today, my lord, on my personal part, my lord. I have
On the prayer of
informed-
Mr. A.R. Bia, learned counsel for the petitioner. Learned senior counsel for the petitioner. The matter be listed again on 16/6/2026.
My lord, 16 I have filed in
17, 15,
18, I will be there.
18,
My lord.
18,
On that day, my lord, I will not.
18,
take any-
so and so, 18/6/2026 for further hearing.
My lord.
I will.
Obliged.
Oh, check up the law.
Yes, my lord, it is very it is their discretion, my lord, and it is also proved that fraudulent activity was there. But my lord, it's just like I am going through life imprisonment and without food, I cannot survive. This is the only source of food, my lord.
But that food also will depend on the nature of your.
Conduct, my lord. My lord.
Supreme Court is very clear on that.
My lord.
We'll see.
My lord.
Find
Obliged.
something, come with.
Yes, sir.
Or there are decisions of the Supreme Court how to apply this compassionate act.
Yes, compassionate allowance, my lord.
Okay.
Obliged.
Mr. Bhuya is having some problem. Why should we will have to not ignore that.
Obliged.
Bhuya, take your time.
Well,
Tuesday we'll do it.
My lord, with regard to item 16, my lord, Mr. A. Fukon, who was conducting, my lord, due to some medical urgency, he has to leave.
What happened?
His grandfather fell in the bathroom, my lord, so
Grandfather or father?
grandmother, my lord. So,
I have a petition about, there is a urgency in this matter, my lord. Can it be on Thursday next, my lord?
A prayer is made on behalf of Mr. A. Fukan, Learned Standing Council, Elementary Education Department for an adjournment in the matter on account of a family,
not a
of a
education
medical
matter,
emergency
Malak.
arising in the family, in his family.
But this is not an education matter, my lord.
Not an education matter.
My lord.
What is it then? Oh, GDA,
Malak.
SAD.
Malak.
Standing Council, SAD, Secretariat Administration, General Administration Department. Awesome. As agreed to by the Learned Council for the parties, registry to list this matter again on 18/6/20.
Well, can it be, my lord, on 18 I have some difficulty.
When? When?
But can it be Thursday next, my lord?
11.
My lord, there is urgency otherwise also.
11.
that's all.
Yeah. Possible. A good idea. Voting But Miss MS N. Soikia, Learned Council for the petition. Also heard Miss. Who is appearing for the secretary, commissioner and secretary? Also heard Mr. B. Kaushik, Learned Standing Council, Elementary Education Department. And Miss B. Bhuya,
For BTC.
BTC, Standing Council, BTC. Also, the petitioner in the present writ petition has prayed for a direction upon the respondent authorities to modify, has prayed for a modification of the order dated 1/4/2022, by which his services were regularized with prospective effect. The petitioner has prayed for a further direction upon the respondent authorities to authorize to him to consider his case under the provisions of the Assam Services Pension Bracket or Pitot Pension Rules 1969, and to reckon his services and reckon the services rendered by him with effect from 4/12/1999 for the purpose of fixation of his pay and allowances, as well as for the purpose of his seniority, pension, etc. As projected in the writ petition, as projected in the writ petition, the petitioner, in pursuance to a selection, was appointed as a stipendiary teacher in Rotanhalli LP School, wide an order dated 4/12/1999, issued by the Deputy Inspector of Schools. Toron, Mongolri. So, it is projected in the writ petition that after joining in his services, the service book of the petitioner was opened and he was subsequently authorized the regular scale of pay with effect from 1/3/2000 and was also enrolled for the group provident, general provident, under the General Provident Fund. Also, the petitioner further projects that in the year 2003, he was deputed for undergoing basic training at the Principal Basic Training Center, Dolgaon, and he had successfully completed the said course. So, upon completion of his basic training course, the petitioner was authorized, was continued to be authorized a scale of pay along with other allowances. The petitioner projects that he received his salaries till 28/2/2007. However, in the month of July 2008, however, with effect from July 2008 report received his salary till June 2008. However, with effect from the month of July 2008, the petitioner salaries of the petitioner were withheld, and subsequently, via an order dated 9/10/2012, the services of the petitioner came to be terminated, along with other similarly situated persons. Also, the petitioner projects that, being aggrieved by the order of his termination, he had approached this court along with other similarly situated persons by way of filing a writ petition being WPC number 528/2008. This court, a coordinate bench of this court, wide order dated 18/11/2009, was pleased to dispose of the said writ petition by following the directions passed by order dated 15/2/2019 in WPC number 2168/2017. Also, the petitioner, the petitioner projects that persons appointed along with him as stipendiary teachers way back in the year 1999, in pursuance to directions passed by this court in writ petitions filed by them, were reinstated in their services and adjusted against sanctioned vacant posts available in the matter. However, the same benefit was not extended to the petitioner in the matter.
No, he is working since, my lord, 2005, his service was regularized, giving effect from 2000. Sanction vacant post.
Who?
Petitioner, my lord.
No, I'm saying about the similar persons who were given immediate reinstatement. You were not given. Subsequently,
Yes.
it was come. Also, subsequently, the respondent authorities, more particularly the Director of Education, Bodoland Territorial Council, by an order dated 1/4/2022, proceeded to accommodate the petitioner as an assistant teacher in a primary school on temporary basis, and against a post created personnel to him. So they said order further required the petitioner, further stipulated that the petitioner would be covered under the new pension rules. So the said appointment of the petitioner was stipulated in the said order to be effected with prospective effect from 1/11/2020. Also, subpara, being aggrieved, the petitioner has instituted the present writ petition. Para divide, it will tomorrow paragraph on that para. Ms. M.S.N. Soikia, learned counsel for the petitioner, by referring to the materials brought on record in the present writ petition, has submitted that the petitioner was so appointed as a stipendiary teacher, wide the order dated 4/12/1999 in pursuance to a selection process initiated wide a notice dated 1/1/1997. Also, he submits that the said appointment she submits that the said appointment of the petitioner being in pursuance to a process of selection, the initial appointment of the petitioner cannot be held to be illegal and or irregular. He submits that the petitioner was granted his scale of pay immediately after he was subsequent to his appointment, and he continued to enjoy the said scale of pay. The petitioner, in terms of the procedure prescribed, was also deputed for undergoing basic training course, and the petitioner having successfully completed the said course, the scale of pay as authorized to the petitioner continued to be authorized to him, and he received his pay and allowances in the scale of pay as mandated for the post held by him. She submits that the respondent authorities, without appreciating submits that the PTC authorities, without appreciating the background leading to the appointment of the petitioner in the present proceedings, had issued an order dated 9/8/10/2012 terminating the services of the petitioner. She submits that the said termination was effected in respect of 285 teachers, and the petitioner was also, name of the petitioner was also included in the said order of termination. However, without examining as to whether the initial appointment of the petitioner was made in a manner, was made the procedure mandated in this connection. She further submits that, being aggrieved by the order of termination, the petitioner, along with 3 others, had approached this court by way of instituting WPC number 528/2018. The said petition is projected to have been disposed of by a coordinate bench of this court-wide order dated 8/11/2019, and therein by noticing the directions passed in WPC number 2168/2017, similar direction was made applicable to the case of the petitioner. Fuso. Ms. Saikia submits that this court, having directed the reinstatement of the petitioner, the respondent authorities, however, miserably failed to comply with the directions passed by this court-wide order dated 8/11/2019, and the petitioner's services were left hanging, although the petitioner is contended to have been rendering his services in the school concerned during the set period. Ms. Saikia submits that the respondent authorities, without assigning any reason whatsoever and in clear violation of the directions passed by this court in wide order dated 8/11/2019 in WPC number 528/2018, proceeded to issue an order dated 1/4/2022 accommodating the services of the petitioner against a newly created post and holding the said post to be personal to him. So she submits that the services that the said accommodation of the petitioner was made effective with effect from 1/11/2020 only. So the services rendered by the petitioner since the date of his initial appointment, that is with effect from 4/12/1999, were ignored and the said service was wiped out. So she submits that on account of the stipulation now made that the services of the petitioner would be only reckonable with effect from 1/11/2020, in the order dated 1/4/2022, the petitioner came to be placed under the provisions of the new pension scheme. She submits that the petitioner being in service, in continuous service with effect from 4/12/1999, the petitioner ought to have been brought under the provisions of the Assam Services Pension Rules 1969 with regularization of the period when he had to remain out of service on account of the operation of the termination order passed in his case, while the order dated 8/10/2012. Also, accordingly, she submits that the order dated 1/4/2022 would mandate a modification and prays that this court would direct the respondent authorities to give effect to the said order with retrospective effect, that is with effect from his date of initial appointment, that is with effect from 4/12/1999, with all consequential benefits of pay, seniority, pension, etc. Fuso. Ms. Fuso. Per contra, Ms. B. Bhuya, Learned Counsel, appearing for the respondents, the BTC authorities, senior counsel appearing for the BTC authorities, has at the outset submitted that the petitioner had accepted the order dated, the stipulations made in the order dated 1/4/2022 and had submitted his adjoining report in the matter. She submits that the petitioner, while submitting his joining report in pursuance to the order dated 1/4/2022, had not raised any objection with regard to the stipulations made therein. She submits that it is only after more than 1 year of his joining in pursuance to the order dated 1/4/2022 that the petitioner has instituted the present writ petition on 1/12/2023. Ms. Bhuya further submits that the decision rendered, of the submits that the order passed by this court widely submits that the directions passed by this court wide order dated 8/11/2019 in WPC number 528/2018 is in view of a direction passed in case of similarly situated persons by a division bench of this court in writ appeal number 182/2013. Also, the petition herein was held to be covered by the said decision of the division bench in writ appeal number 182/2013. She submits that the persons covered by the decision of the division bench of this court in WA number 182/2013 had on their were regularized immediately after the passing of the said directions in accordance with the decision arrived at in the matter by the BTC authorities. Also, however, subsequently, the said persons were again regularized in their services in the year 2022-2024 and were held to be entitled to receive their salaries only with effect from the subsequent second regularization effected in their respective cases. Also, she submits that the second regularization as affected in case of the persons covered by the decision of the division bench in writ appeal number 182/2023 is similar to the regularization of services affected in respect of the petitioner herein wide the order dated 1/4/2022 and 1/4/2022. She submits that the said persons whose services were held, who were entitled to receive salaries and other service benefits in terms of their second regularization affected in their cases in the year 2022-2024 had approached this court by way of filing various writ petitions, including WPC number 6020/2017. A coordinate bench, she submits that a coordinate bench of this court had considered the issues arising in WPC number 6020/2017 and other analogous matters, and wide judgment and order dated 14/7/25 had proceeded to dispose of the said writ petitions by holding that the petitioners therein would be entitled to receive their salaries only with effect from the second regularization effected in their cases against sanctioned valid post created for the purpose. Proceeded to dispose question or dismiss query. Accordingly, she submits that the said decision would squarely apply to the facts arising in the present writ petition. Also, rejoining her submissions, Ms. N. Shekya, learned counsel for the petitioners, submit that the decision of the coordinate bench of this court in WPC number 6020/2017 and other analogous matters would have no application insofar as the case of the petitioner is concerned, and her case has to be so considered basing on the decision rendered by this court-wide order dated 8/11/2019 in WPC number 525/2018 instituted by the petitioner herein. Where is this order dated 21/3/25, 2005? He
Regulation.
submits that
Regulation.
the petitioner, on completion of his basic training course, having been
Was 31.
authorized to receive a regular scale of pay against a valid sanction post, comma, the said order must be construed to be the order regularizing the services of the petitioner, and accordingly, accordingly it being permissible to consider the stipendary period of service rendered for the purpose of considering the service, considering the service length of service of a stipendary teacher after regularization of his services on acquiring the junior basic training on clearing the junior basic training course, comma, she submits that the petitioner, the services of the petitioner for the purpose of authorizing to him his salaries, comma, and other service benefits must be so construed from 4/12/1999 and not from a date pursuant thereof.
It is 31 million.
Hmm?
31 be giving regulation effect from 2/3/2000.
Now, if you are a stipendary Purnima,
Yes,
it will go back to that date. So, I have heard it. Anything further to be brought in? Nothing? Anything further to be?
He has worked, my lord, but salary is not given from 8 to 12.
He is being not paid from 2008 onwards.
So July 2008 to 12, my lord, page 12, my lord, page 12.
Page 12.
The prior portion, last 1/7/2008 to 8/10/2012.
Accordingly, Ms. Soikia submits that this court would be pleased to direct would direct the respondent authorities to release to the petitioner his salaries in arrears with effect from 1/7/2008 to 8/10/2012 and with effect from 8/11/2019 to 1/4/2022, along with a direction to consider the petitioner to be covered by the provisions of the rules of 1969 for the purpose of his entitlement to pension and other pensionary benefits. I've heard the learned counsel for the parties and peruse the materials available on record. So, at the outset, this court would examine as to whether the petitioner was so appointed basing on a regular process of selection as mandated under the rules holding the field. The petitioner in the pleadings brought in his pleadings brought on record in the present writ petition has submitted that his such appointment was in pursuance to an advertisement dated 1/11/1997 issued by the Deputy Inspector of Schools, Dorong. So while the said contention has been made by the petitioner in the present writ petition has not brought on record any select list pursuant to which the petitioner's appointment was so affected by the order dated 4/12/1999. A perusal of the order dated 4/12/1999 also does not reveal that such selection or such appointment of the petitioner was in pursuance to his selection for the post in question. Another fact which comes to the notice of the court from the materials brought on record is that the petitioner, after he was so appointed with effect from 4/12/1999 as a stipendary teacher, was subsequently authorized his pay and allowances in the scale of pay as authorized to an assistant teacher in a primary school without however requiring the petitioner to acquire his junior basic training certificate. The petitioner continued to receive his pay and allowances in the scale of pay even before he was so deputed for undergoing the junior basic training course by the respondent authorities. The petitioner having completed his said training course, the Director, Elementary Education, Assam, Kahilipara, vide an order dated 21/3/2005, proceeded to permit the petitioner to draw his scale of pay with effect from 5/3/2004. That is the date when the result of the said basic training course was so announced. So, while the said order was issued, allowing the petitioner to draw his pay and allowances in the scale of pay mandated. Also, the defect as the full stop. The same cannot, in the considered view of this court, remedy the illegality committed in appointing the petitioner while the order dated 4/12/1999 without there being a selection, without he having qualified in a selection held in terms of the rules holding the field. Also, the PTC authorities, on appreciating the said position coming on record, had proceeded to issue an order dated 8/10/2012, terminating the services of the petitioner along with another 284 numbers of teachers who were appointed in Darang district as a Darang district in lower primary schools. The said termination of services so affected while the order dated 8/10/2012 was in view of the fact that the said teachers, including the petitioner herein, was found to have been appointed without there being a due selection process carried out in the matter in their respective cases. Also, persons similarly situated like the petitioner herein, being aggrieved by the termination effected in their respective cases by the BTC authorities, had approached this court by way of instituting a writ petition being WPC number 58, by instituting writ petitions, including writ petition number 5840/2009. A coordinate bench of this court, on considering the issue arising in the proceedings of WPC number 5840/2009 along with 2009, along with other analogous matters, proceeded by judgment and order dated 2/7/2010 to dismiss the said writ petition, upholding the termination effected in case of the petitioners therein. Also, being aggrieved, the said petitioners approached the division bench of this court by way of filing by way of instituting a writ appeal, being writ appeal WA number 182/2013. The division bench of this court, appreciating the policy decision taken by the BTC authorities to the effect that persons who were receiving salaries regularly from the month of March 2006 would be regularized, and that the said policy was in the process of being implemented, had proceeded while order dated. When is the order of the division bench?
Division bench, fine.
While order dated 6/2/2015, proceeded to dispose of the said writ appeals while order dated 6/2/2015, holding the petitioners therein to be entitled to directing the respondent authorities to effect the regularization as per the policy decision arrived at in the matter in respect of teachers who had regularly received salaries up to 17/10/2006. Also, the petitioner herein being aggrieved by the termination effected in his services had approached this court by way of instituting a writ petition being WPC number 528/2018. A coordinate bench of this court, by order dated 8/11/2009, proceeded to dispose of the said writ petition with the following observations and directions. Page 44. A2. Page 46A. A perusal of the directions passed by the coordinate bench of this court, wide order dated 8/11/2019, would go to reveal that the said directions were so passed basing on the order dated 6/2/2015 passed by the division bench of this court in in writ appeal number 182/2013 and other analogous matters. Accordingly, the direction for implementation of the policy with regard to reinstatement in service of the similarly situated teachers whose services were terminated by the BTC authorities was also applied in respect of the petitioner herein. Also, the grievance raised by the petitioner in the present writ petition is that after passing of the directions by this court in WPC number 5/28/2018, his services where he was not reinstated in his services, whereas persons similarly situated like him in the year 1999 whose services were also terminated were reinstated in their services and adjusted against sanctioned vacant post. Also, the petitioner is not found to have approached this court with regard alleging violation of the directions passed by this court wide the order dated 8/11/2019 in WPC number 528/2018. So, the respondent authorities on processing the case of the petitioner and after receiving the due approval in this connection from the Education Department, Government of Assam, proceeded wide order dated 1/4/2022 to adjust the services of the petitioner as an assistant teacher against a newly created post, against a post created for the purpose. The said post was so created with the stipulation that it would be personal to the petitioner herein. A perusal of the order dated 1/4/2022 would reveal that the accommodation made in respect of the services of the petitioner was so made against a post created for the purpose with effect from 1/11/2020 and not prior thereto. The petitioner was held to be eligible to receive his salaries only with effect from 1/11/2020. Further, the petitioner, in view of the fact that he was now appointed with effect from 1/11/2020 against a valid sanction created post, brought under the provisions of the new pension rules. The petitioner, as projected by the respondents, had accepted the said stipulations, made in the order dated 1/4/2022 and had joined his services without raising any objection. It is only after a lapse of around 1 year from the date of his of the passing of the order dated 1/4/2022 that the petitioner had instituted the present writ petition. The prayer in the present writ petition is primarily for giving effect of the accommodation made in his case against a valid sanction post with retrospective effect. That is a period covering the period when the petitioner had remained out of service on account of being terminated from his services. This court finds that an issue similar to the one raised in the present writ petition was raised before this court in the proceedings of WPC number 6020/2017, Ganesh Narzari and others versus State of Assam and others, WPC number 6022 likhichu na bracket ot etu likhi dile. Also, a coordinate bench of this court considered WPC number 6020/2017 along with other analogous matters and had dismissed the claims made therein, while judgment and order dated 14/7/2025. Also, the coordinate bench of this court, upon appreciating the submissions made by the learned counsel for the parties, had framed an issue for consideration to the effect that as to whether the petitioners in the said proceeding were entitled for regular salary with effect from the first regularization, or whether they are rightly being given their service benefit, including their salaries with effect from the second regularization. The coordinate bench thereafter, on examining the background leading to the decisions taken by the BTC authorities for reinstatement of teachers who were terminated, as well as the orders, as well as the directions passed by this court, by the division bench of this court, while order dated 6/2/2025 in W Writ Appeal number 182/2013, had proceeded to draw a conclusion that the initial regularization of the petitioners therein was so made without an approval in the matter being received from the state of Assam, which was held to be mandatory in terms of the memorandum of settlement, memorandum of understanding, basing on which the BTC, Bodoland Territorial Council, was created. Further, it was held that the concurrence of the Finance Department, Government of Assam, was also not received before the first regularization was effected in respect of the said teachers, and that the Finance Department was not a transferred subject. So, having drawn the said conclusions, the coordinate bench of this court drew the following further conclusions. Page 156, Roman 24, 10:10:4. B2. B2B. B2. So this court has closely perused the conclusions drawn by the coordinate bench of this court in the case of Ganesh Narzari and others, Supra, and is in respectful agreement with the conclusions so drawn. So, the regularization of the services of the petitioner by way of accommodating him against a newly created post is found to be so effected after the approval in this connection was received from the government in the Department of School Education, as well as concurrence from the Finance Department. So this court, having already concluded that the initial appointment of the petitioner being dehorsed the provisions of the rules holding the field, the petitioner not having brought on record any select list wherein his
letter
name.
I have given.
Huh?
Interview calling letter I have given. And
Select list is not there.
select list is not our custodian.
Can't help it.
He under RTI, but the district has been separated.
Okay, fine. Select list has been brought on record wherein his name figures which had led to his initial appointment effected while the order dated 4/12/1999. Accordingly, the accommodation of the petitioner with prospective effect, that is with effect from 1/11/2020 as affected while the order dated 1/4/2022, in the facts and circumstances of the present writ petition, in the considered view of this court would not mandate an interference. Also, the petitioner, in view of the background leading to his appointment as well as his continuance therein, would not permit this court to further direct the respondent authorities to also authorize to the petitioner his pay and allowances with effect from 1/7/2018. Also, accordingly, the claim made by the petitioner in the present writ petition is found would not mandate an acceptance, and the prayer for a modification of the order dated 1/4/2022 to make it effective, to make it operative with effect from the date the petitioner was so effective from the date the petitioner was paid his salaries in the regular scale of pay, would also not mandate an acceptance. Accordingly, for the reasons assigned herein above, the present writ petition is held to be devoid of any merit and the same stands dismissed. However, there would be no authorized request. Sorry, Mr. C.
I only paid my note, page 31. His service was regularized. Giving effect from 2000. So second regulation.
The learned counsel for the petitioner has placed a respectful, at this stage, it is to be the contention raised by the learned counsel for the petitioner that the petitioner's services were regularized while issuance of an order dated 21/3/2005 is being considered. This court has perused the order dated 21/3/2005 and finds that the said order was so passed after the petitioner had completed his basic training course. Also, the said order had authorized to the petitioner his regular salary against a valid sanction post. Also, as noticed herein above, even before the petitioner was deputed and had cleared his basic training course, the petitioner was authorized his scale of pay, which was clearly impermissible, inasmuch as in the case of a stipendiary teacher, a scale of pay is mandated to be authorized only after he had completed his basic training course, full stop. Accordingly, this court is of the considered view that the order dated 21/3/2005 cannot regularize an illegal appointment effected in respect of the petitioner while the order dated 4/12/1999, which as held herein above was so done clearly in derogation of the provisions of the rules holding the field. Accordingly, the contention of the learned counsel for the petitioner that the order dated 21/3/2005 had the effect of regularizing the services of the petitioner is rejected, and the petitioner is held to have been appointed on a regular basis only upon passing of the order dated 1/4/2022 with effect from 1/11/2020. Thank you.
Advertisement, because select list is not a custody and district has been separated, so they could not, RTI was filed, but they could not.
But in your earlier decision, 182 was followed. Writ appeal number 182 was followed. You took that order.
Yes.
So now you have taken that order. The consequence.
The other persons have been his friends who were pass together, training together.
Yeah,
They have been,
if
they are
that
still
is
a benefit. He has been only single out.
So, the further contention of the petitioner that persons similarly appointed along with him in the year 1999 were reinstated in their services and appointed in a vacant sanction post subsequently on revocation of their order of termination. However, the said benefit was not extended to the petitioner hearing, is being considered only to be rejected, comma. The action on the part of the PTC authorities in reinstating persons whose services were terminated after the passing of the directions in writ appeal number 182/182 of 2013 has already been considered by a coordinate bench of this court in the proceedings of, in the case of Ganesh Narzari and others, and this court had concluded that the said reinstatement being without the approval of the Government of Assam Government of Assam in the Education Department as well as the Finance Department of the Government of Assam would be of no consequence. Accordingly, the said illegality as committed by the BTC authorities in reinstating persons similarly situated like the petitioner in services without the receiving an approval in this connection from the Government of Assam in the Education Department, as well as concurrence of the Finance Department, Government of Assam, in the considered view of the court was an illegality, and this court, by directing the respondent authorities to accommodate, to apply the same yardsticks in respect of the petitioner hearing, would in fact be perpetuating an illegality which this court refrains from doing so. Thank you. Can't help it.
I think it was a good case.
There is a,
I think it was good for, I think it is a good case for on merit, my lord.
ma'am, you have always an opportunity of appeal.
Because they are not selected, not against advertisement. Ordinary bench cases have been the additional affidavit thoroughly
But
compared.
that is 182. You should not have taken that order by following 182. Simple. That's the only thing which, I was with you earlier, but that is the thing which changed. Yeah. Tomorrow. Hey, Mati, modify. আৰু কি আছে কোনটো supervisor Ms. Gayana, have you got that what is there? This is warrant officer. They are known as warrant officers. Clerk. Where is that clerk thing here? This is warrant officer.
Your Lordship, I have the copy of this notice.
Havildar clerk, yes,
Yes.
yes. No, where is that Havildar clerk? The relaxation can be made by the director.
In earlier occasion, I have submitted one document, my lord. This is the competent person, but that is in the.
No. In the Havildar clerk rules, it is the government, not the
Central government, yes, my
central
lord.
government.
Yes, ma'am, that is
And
there,
where
my
is
lord.
the delegation?
Yes, my lord.
No. I'll till my steno comes only.
Acha.
You said, yes, where is that delegation?
Delegation is not there, my lord.
Then?
But my submission is that the necessary parties are not made in this, my lord, because
Oh,
of.
that is different. You have filed an affidavit here saying
Yes, my
that
lord.
you have relaxed the rules.
Yes, my lord.
Now, once you have relaxed the rules, that means that relaxation can only be by a competent authority.
That is the
He
central
is not
government.
the authority.
Central government is the competent as per the rule, my lord. That is there, my lord. Rule is there, my lord.
The rule, the delegation, the rule that you have produced
Yes, my
is
lord.
for somebody, something other.
Yes, my lord.
Ms. Gan, then Mr. Beria's thing has to be now taken. How many appointments were made? 100?
Yes, my lord. 100 appointments, my lord. In 2018, my lord. They are still working, my lord, from more than 8 years. So I think they are the necessary party in this petition, my lord.
That we can always
Yes, my lord.
require Mr. Beria to do.
Yes, my lord.
Thing is, we were misled by the authorities,
Yes,
saying that the power of delegation, power has been delegated to the director. That's why I was against Mr. Beria.
Yes, my lord. But in this rule, my lord, this is.
But Mr. M. Beria, learned counsel for the petition. So heard Ms. A. Gayan, learned counsel. Learned CGC appearing for the respondents. The respondents on queries being raised by this court with regard to the power to relax the provisions of the rules had filed an
Additional affidavit, my lord.
had filed an additional affidavit in the matter on 25/2025, and therein had taken a plea to the effect that the provisions of the rules Where is that prescription in the advertisement, Mr. Beria?
Page number 26 regarding the skill test now.
Committed that the skill test norms on computer with regard to Hindi typing, English typing was reduced from 35 words per minute to 20 words per minute, and for the purpose, the approval of the competent authority was received. The competent authority was projected to be the Director General of Assam Rifles. Also, during the hearing held on 8/6/2026, this court had required Ms. Gayan as well as Mr. Beria to place on record a full copy of the rules holding the field. A copy of the said rules pertaining to recruitment to the post of Havildar Clerk in Assam Rifles has been placed on record. This court, on a perusal of the said rules, finds that the power to relax under Rule 8 is vested in the central government. No further delegation is found in respect of the power to relax the rules to have been also delegated to the Director General of Assam Rifles. Full stop. The rules as presented as placed before this court by the respondent authorities, wherein the power to delegate the power to condone the rules was delegated to the Director General of Police, Director General of Assam Rifles, is with regard to the provisions of the rules as existing in the matter prior to 2013. However, the selection in question having been, however, the advertisement in question having been issued in the year 2017, it is the provisions of the rules of 2013.
13, my lord.
Of the
Assam
rules of
Rifle.
2013. Rules of the Assam Rifles Havildar bracket clerk recruitment rules 2013 that would hold the field. Also, in the above development taking place in the matter, Ms. Gain is directed to file a detailed affidavit highlighting as to why the relaxation was so affected by a authority not competent to effect such relaxation. The said affidavit be filed on or before 25/6/2026. Registry to list this matter again on 14/7/2026. Also, in the event, it is further provided that the said issue having come to the notice of this court, in the event this court is required to interfere with the selection process, the same would have the effect of interfering with the selection of around 100 candidates who were recruited with the relaxed qualification in the selection process. However, it is seen that the said candidates are not party respondents before this. The petitioner is permitted to take appropriate steps for the purpose of implementing the selected candidates as party respondents in the present matter before the next date of listing. Registry to list this matter again on 14, 14/7/2026.
An impossible task to implement 100.
I just put it, you don't want, you make your submissions. There is no problem. Yeah. WPC 4573/2020. Heard Mr. A. Hussain, Learned Counsel for the petitioner. Also heard Mr. B. Talukdar, Learned Standing Counsel, Elementary Education Department, appearing for the respondents number 1, 2, 5, 6, 5 and 6. Also heard Ms. M. Bachaji, Learned Additional Senior Government Advocate, appearing for the respondents number 3 and 4. Oh no, 1, 2, 3 what question? 4, only 4. Full stop, semicolon. Mr. Who is for 7? Respondent number 7.
None appears.
Huh? Full stop. Mr. J. Abedi for respondent number 8 and Mr. D. A. Kaim for the respondent number 9. None has appeared for the respondent number 7. The petitioner in the present proceeding has assailed the provincialization effected in respect of the respondents number 7.
No, my lord, 8.
8 and 9.
8 and 9, please.
In respect of the respondents number 8 and 9 as tutors in Kalani Zala Nobo Roshmi ME School in under the provisions of the Act of 2017. Also, as projected in the writ petition, the petitioner was in pursuance to a resolution adopted by the managing committee of Kalani Zala Nobo Roshmi Beleg Middle English School, English Madrasa, was appointed as a assistant teacher by an order dated 26/8/2003. The petitioner is projected to have petitioner contends to have joined her services in the said school with effect from 28/8/2003. The petitioner further projects that upon joining the said school, he was continuously teaching the subject of ASMIS in the said school. Also, after the enactment of the provisions of the Act of 2017, the school of the petitioner being found to be eligible, to satisfying the eligibility criteria specified for provincialization of the services of the teachers working in the said school, the particulars of the teachers working in the said school came to be submitted before the respondent authorities by the respondent number 7, who at the relevant point of time was functioning as the headmaster of the said school. The service particulars of the petitioner was also forwarded along with the other teachers working in the said school. The jurisdictional district scrutiny committee, on verifying the service particulars of the petitioner, of the teachers working in the said school as placed before it, proceeded to recommend the names of the respondents number 7, 8, and 9, along with the names of 2 other teachers working in this school for provincialization of their services. Also, the petitioner being aggrieved by the provincialization as affected in respect of the respondents number 7 and 8 hearing, approached this court by way of instituting a writ petition being WPC number 3339/2021. A coordinate bench of this court, wide order dated 23/7/2021, accepting the contentions raised by the petitioner qua the respondent number 8 herein, Azhar Uddin Ansari, while issuing notice in the said writ petition, was pleased to direct that in the interim, the further effect of provincialization be not extended to the respondent number 8 herein until further orders. The said writ petition was subsequently disposed of by an order dated 2/3/2023, requiring the petitioner to approach the appellate authority, to approach the state government as appellate authority under section 14 of the Act of 2017. Also, the appellate authority was directed to afford an opportunity of hearing to the petitioner as well as the respondent number 8, and thereafter to dispose of the appeal. Also, the interim orders passed in the said writ petition was directed to be continued with till the appeal as directed to be preferred by the petitioner is disposed of. Also, the petitioner accordingly preferred an appeal before the Government of Assam, before the Secretary to the Government of Assam, Department of School Education. Also, the said appeal was disposed of by the Secretary to the Government of Assam Department of School Education, wide an order dated 10/7/2023, by holding therein that the name of the petitioner not being recommended by the jurisdictional district scrutiny committee, the case of the petitioner could not be recommended for provincialization of our services under the provisions of the Act of 2007. Accordingly, the claim of the petitioner for provincialization of our services came to be rejected. There being a delay in issuance of the order by the appellate authority, the petitioner had in the meantime instituted a contempt case being COPC number 61 of 2024. This court, by order dated 21/6/2024, noticing the irregularities occasioning in the passing of the order dated 10/7/2023 and the petitioner not being granted an opportunity of hearing prior to passing of the said order, had directed the respondent authorities to afford an opportunity for fresh hearing in the matter to the petitioner and thereafter to pass appropriate orders in the appeal so preferred by the petitioner. The respondent authorities, the appellate authority thereafter afforded an opportunity of hearing to the petitioner, and after conclusion of the hearing, while order dated 8/7/2024, proceeded to reject the claim of the petitioner for provincialization of her services by holding that the petitioner was initially appointed as an assistant teacher and not as a language teacher. Accordingly, her case would not be permissible to be recommended for provincialization of her services as per the provisions of the Act of 2017. So the petitioner, being aggrieved, has instituted the present writ petition. Mr. A. Hussain, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner was the only teacher teaching the subject of Assamese in the school since the date of her initial appointment, which had occasioned why the order dated 26/8/2003. He submits that the respondent number 8 is both respondent number 7 and 8 are admittedly junior to him with respect to the dates of their respective appointments in this school. Accordingly, he submits that the juniors to the petitioner could not have been considered for provincialization of their services prior to such consideration being extended to the petitioner hearing. Mr. Hussain, by taking this court through the materials available in the present writ petition, has submitted that given the enrollment status of students in the said school, the respondent authorities had sanctioned 5 posts to the school for provincialization of the teachers working therein. He submits that as none of the teachers considered for provincialization had the requisite qualification, all the teachers were so provincialized. Even the science teacher is a tutor.
My lord.
All the teachers were provincialized as tutors. Also, he submits that a post of headmaster was also not sanctioned to the said school in all probability. Because the respondent number 7, who was serving as the headmaster of the said school, did not have the requisite qualifications for the post. Mr. Chaudhary, what are you waiting for?
Item number 21. There's some urgency, my lord. Small matter.
This, I have one, there is the one.
Okay.
2 are there.
Can I take a chance on Thursday, my lord?
Oh, yeah, sure. Just make a mention
Yes.
on the prayer of the learned counsel for the parties 21, registered to list this matter again on
তোমালোকৰ benefit পাই আছে আমি পোৱা নাই
18th,
Monday, my lord.
Monday,
Sorry,
Thursday.
Thursday.
This Thursday.
Yes, my lord.
What is the issue? I just forgot.
Your Lordship knows for promotion from the forester to deputy ranger,
Hmm.
there are 2 processes.
Hmm.
One is 6-1 and 6-2.
Hmm.
We are higher on merit, so we were promoted. Our promotion was cancelled, my lord.
You were 1, 2, 3.
We were 6-1.
No, 6-1 means that.
1 to 3.
1 to 3.
1 to 3, right.
Then?
Then, my lord, we were promoted.
Ah.
Then, my lord, our promotions were cancelled. Similarly, my lord, promotion of some rangers were, forester grade 1 also cancelled.
Oscar Deca.
Then, my lord, a writ petition was filed by the rangers, foresters, my lord, their writ petition was allowed and their promotion has been restored. But our promotion has not been restored.
You are in the lower,
No, we are in the deputy ranger.
you are deputy ranger. Those were rangers.
Those were rangers, not
They-
rangers, my lord, forester grade 1.
Grade 1. They were promoted as deputy ranger.
Because now what has happened, now those who have got promotion under 6(2), that is by virtue of seniority, they are sought to be further promoted, my lord, disregarding our case. That is the urgency.
And you are for?
He is for the, my lord, promotees under the
What
regular.
is your case?
Our case is, here promotion is not as per, not
No, means whether they were also trainees in the,
trainees.
in approved
Approved.
colleges,
Ah,
Yes.
yes,
in the Assam Ranger College.
yes,
Results were published.
yes,
Whether they were 1, 2 and 3.
yes,
1 and 75% and above.
yes, 70 and above.
Training. Now we are from, my lord.
That is training of the, for ranger training.
Not, my lord, ranger is another one, that is
Another
in
one.
Karshiang, and
What
this is for, my lord,
forestry.
forestry.
Training in the Assam forest
College.
school. So therein the requirement is that if you come within that
1, 2, 3.
and above,
Ah.
6(1) or 6(2) of the
6(1),
forest-
my lord.
6(1) says that they will be given en bloc
Yes,
promotion,
those who are on merit.
merit. That goes on merit.
Ah.
Then the other category is
By seniority come
there
merit.
are decisions, I forgot. There are decisions of this court touching on this point.
Yes.
Ascot Deca. Ascot Deca.
We'll find out, my lord.
Ascot Deca. That is the name I remember. I appeared in one of the.
Now, my lord, our urgency is now they're the promotees under the second group.
Hmm.
Now they are sought to be further promoted disregarding our cases. That's why the urgency. my lord.
So, my lord, one more thing. In our, so many candidates.
Excellent file to some. First, I just missed out this matter.
Ascot Deca will try to find out.
There is
Some
some
more file to
issue there. M.K. Chaudhary will know.
Okay, we'll ask him. My lord, I think that was a case of forest ranger, my lord.
Maybe ranger.
Even I am involved in that case.
You were also. I
It
think.
is a case of forest ranger.
Ah.
Now, for example, if your lordship kindly takes WPC 5586, page number 56, my lord. For example, petitioner number 1, Dayananda Rongpi, second topper.
56.
6 is the petitioner number 1. Second topper in 6 months induction training for foresters commenced from 1st January to 30th June is awarded with the Forest Minister's Award. Similarly, my lord, Satyajit Ray secured second highest. And as far as my lord marks are concerned, training certificates, marks to good goal.
That is why I can't take up this matter.
Lord?
Page 128, I am there.
128, my lord.
Is it covered? What is the relation with 128 in this case?
1 second, my lord.
Annexure B.
You can hear. Oh, yes.
As prayed for by the learned professor, registry to list this matter before any other bench without me. As prayed for by the learned counsel for the parties, registry to list this matter on 11/6.
Yes.
2026 before an appropriate bench.
Yes.
That's why this.
There's one more matter. Can I pray for little accommodation?
Yeah.
Item 25, my lord. Some other day, my lord.
As prayed for by the learned counsel for the parties, the registry to list this matter. We'll have it after vacation.
Miller.
On 21 would be fine.
Miller, yes.
21/7.
Diplom.
Itu my divam. Yeah. Man quote to film. Huh? Full stop. Mr. Hussain, after referring to the date of engagement of the teachers in the said school, referring to the date of the teachers whose services have been provincialized, the date of appointment of the teachers whose services have been so provincialized, along with the subjects they were teaching in the school, including the date of appointment of the respondent number 7, 8, and 9, submits that in terms of the provisions of section 3 bracketed 11 of the Act of 2017, comma,
page 111, madam.
there would be no dispute with regard to the provincialization of services of Bharat Chandra Das as the science and mathematics teacher. However, he submits that with regard to the provincialization of services affected in respect of the other teachers, comma, a dispute would arise inasmuch as the petitioner is basing on the date of her appointment in the school as well as the subject taught by her senior to them except the respondent number 9, Zakir Hussain. So he submits that Zakir Hussain being the social studies teacher, comma, his accommodation also would not mandate and cannot also be disputed. However, Mr. Hussain submits that the provincialization of the services of respondent number 8, Azaruddin Ansari, whose date of appointment was 2/9, date of appointment in the school was 2/9/97 and was teaching the subject Hindi, ignoring the case of the petitioner who was teaching the language subject Assamese, would mandate an interference from the school. He submits that in terms of the provisions of the Act of 2017, the Hindi teacher is not considered as a language teacher, and accordingly, the provincialization of the services of the respondent number 8 as a Hindi teacher would mandate an interference by this court. So he submits that on an interference being made with the appointment, with the provincialization of the services of respondent number 8, comma, the further direction is called upon to be issued to the respondent authorities to appoint the petitioner to provincialize the services of the petitioner as a language teacher in the school. Anything more? This is the thing. Per contra, Mr. Affidavit filed by the state here?
State not filing.
Not filed.
Not filing.
Mr. B. Talukda, learned counsel for the petitioner, submits that the petitioner's initial appointment being as an assistant teacher and her case not being recommended by the district scrutiny committee in terms of the provisions of the Act of 2017, comma, further consideration of the case of the petitioner by the respondent authorities was not permissible, and accordingly, by noticing the said position, the appeal preferred by the petitioner came to be rejected. Mr. J. Abedi, learned counsel appearing for the respondent number 7, by referring to the date of appointment of the petitioner as well as by highlighting that the petitioner was teaching the subject of Hindi in the said school, has placed reliance, has referred to the affidavit filed by the respondent number 8 in the present matter, and has contended that the subject Hindi is a special subject and is mandatorily to be taught in a upper primary school along with the subject of Arabic, which he contends to be, said Arabic also, which he contends to be a to be a mandatory subject in the present school, in as much as the said school was a Middle English madrasa prior to it being designated as a Middle English school. Mr. Abedin, in support of his submissions, has placed reliance on a notification dated 12/12/2000, wherein which has been issued, which by which a uniform guideline has been laid down to be adhered to by the authorities in the education department for the purpose of submission of proposals for according permission recognition to open new ME schools, ME madrasas. He submits that in terms of the prescription made in the notification dated 12/12/2000 for the purpose of granting recognition granting permission recognition to a upper primary school, a post of Hindi teacher is mandatorily required to be included in the list of teachers teaching in the said school. So, Mr. Abedi, by further placing reliance on a communication dated 9/12/2019 issued by the Director of Elementary Education Assam, has submitted that therein the requirement of having therein it was highlighted that the Hindi being a compulsory subject along with Arabic in a Middle English madrasa, absence of a Hindi teacher / tutor in an upper primary school as well as an Arabic teacher in a Middle English madrasa, would have the effect of depriving the students from learning the above they said compulsory subjects. Also, by relying on the said communication dated 9/12/2019, Mr. Abedi submits that the government even after the enactment of the 2017 Act had realized the necessity of having a Hindi teacher, having the services of for provincializing the services of a Hindi teacher, in as much as it was considered that the subject Hindi was a compulsory subject in an upper primary school. Accordingly, he submits that the concerned committees, having considered the subject Hindi to be a compulsory subject in upper primary school, had recommended the case of the petitioner, who otherwise was qualified to hold the post of Hindi to teach the subject of Hindi, for provincialization of his services, and the same having been accepted by the government, they said the provincialization of services of the respondent number 7 would not mandate an interference from this court.
One thing, on last occasion I mentioned that 311 being met, the first 3 condition, I was the 4th, like your lordship. Respondent number 7 was the English language teacher.
Social studies is respondent number 9. And science is Bharat Chandra.
Yes.
Then you have 2 persons left.
2 persons left. Arabic is some
Aisha
Siddiq, whose service has been recommended plus provincialized as an Arabic, and I was recommended and provincialized as Hindi. So first
Mr. Abedin by Mr. Abedin, Learned Counsel for the respondent number 9, by referring
8, respondent number 8.
8 by referring to the provisions of section 3(11), submits that amongst the teachers provincialized in whose services have been provincialized in the school, the respondent number 7, Nasiruddin, was provincialized as a language teacher, while the services of Zakir Hussain was provincialized as a social studies teacher, and the services of one Bharat Chandra Das was provincialized as a science and mathematics teacher. Accordingly, he submits that the main provision of section 311 stood satisfied with the provincialization of the said three teachers. The enrollment of the school in question being more than 100, the respondent authorities had sanctioned further 2 posts to the school. He submits that the said 2 posts would now be required to be was mandated to be so filled up by recognizing that against the compulsory subjects, that is Hindi and Arabic, no teacher in the said school, services of no teacher teaching the said subject came to be provincialized. Accordingly, he submits that the respondents had not committed any error in proceeding to recommend the cases to provincialize the services of the teacher teaching Arabic subject, that is Aisha Siddiqui, and the services of the respondent number 8, Azharuddin Ansari, who was teaching the Hindi subject. Accordingly, he submits that the petitioner, although was senior to the respondent number 8 was junior to the petitioner in the by reckoning. He submits that by reckoning the date of joining services by the petitioner and the respondent number 8, the petitioner admittedly is senior to the petitioner to the respondent number 8 herein. However, she being a teacher of Assamese subject and language, and the respondent number 7 already having been provincialized in his services by reckoning him to be a teacher teaching a language subject, the petitioner was not entitled to the said regularization. So, anything more?
Well, would you Lordship be pleased to glance at page 127 once? My lord got it. My lord, fifth column from the left. So in the 5th column, the last line is the persons who may be provincialized, that is the Hindi teacher, Arabic teacher, language teacher. So only that I wanted to point out.
Mr. Abhinav, further by referring to the schedule as appended to the rules of 2017, submits that in respect of upper primary school, it is permissible to provincialize the services of a Hindi teacher oblique Arabic teacher oblique language teacher. Either anybody more? 9 has filed an affidavit.
Yes. 9 is safe, my.
So, the Learning Council for the respondent number 9 has adopted the arguments advanced by Mr. J. Abedin, Learning Council for the respondent number 8. So, it is further projected that where is the affidavit? Respondent number 9.
My affidavit.
Same.
No, my lord, different. Let case number, my lord, 124.
120. That he on his engagement, on his appointment in the school, which date of appointment was prior to the date of appointment of the petitioner hearing, was teaching the social science subject, and accordingly, his services being provincialized comma. Accordingly, he submits that his services were provincialized, recognized by reckoning the provisions of section 311 of the Act of 2017, and such provincialization as affected in his case would not mandate an interference from this court. Also, I've heard the learned counsel for the parties and peruse the materials available on record. At the outset, this court would notice the date of joining of the teachers whose services have been provincialized in pursuance, provincialized under the provisions of the Act of 2017. The petitioner was appointed in the said school on 26/8/2003. The respondent number 7 was so appointed on 23/3/2007, while the respondent number 8 was so appointed on 2/9/2007. The respondent number 9 is found to have been appointed on 16/8/1997. Also, two other teachers who have not been arrayed as party respondents in the present writ petition, but whose services have been provincialized, are
Bharat Chandra.
Bharat Chandra Das, who was appointed in the said school on 11/8/1999, and Ayesha Siddiq Begum, who was so appointed on 2/3/1995. So, considering the date of appointment of the teachers, it is found that Ayesha Siddiq Begum was the senior most teacher basing on the date of appointment, while respondent number 9, Zakir Hussain, who was appointed on 16/8/97, was the next senior most. The person appointed after Zakir Hussain in the said school is Nasiruddin, that is the respondent number 7, who had also functioned as the headmaster of the school during its venture stage. Thereafter, the petitioner is found to have been appointed in the said school. Accordingly, the petitioner is found to be the 5th senior teacher basing on the date of appointment in this. Azahar Uddin Ansari, whose date of appointment is 29/5/2009, is found to be the junior most amongst the teachers whose services were provincialized and are party respondent and is a party respondent in the present writ petition. Also, section 3, itu pura marivide, section 3 for subject to the provisions of section article 30, and so 1 of 3 to C2. Short 11. Page 108, mildly, first paragraph, page 11, 111, C1 to C. A perusal of the set rules, perusal of section 311 of the Act of 2017 would go to reveal that in a venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics A, B, social studies and languages. In other words, 311 mandates that insofar as a upper primary school is concerned, at least 3 services of at least 3 teachers in terms of the provisions thereof must The service must be mandatorily services so and so must be mandatorily provincialized. So, having noticed the provision of section 311, this court would now examine as to amongst the petition teachers working in the said school, who would be eligible to have their services provincialized in terms of the main provision of section 311. On a examination being made and on a scrutiny of the materials coming on record in the present writ petition, this court finds that Aisha Siddiqui Begum was teaching the subject of Arabic, while Zakir Hussain was teaching the subject of social science. Bharat Chandra Das was teaching the subject of science, and Nasiruddin Zakir Hussain bracketed respondent number 9 ko idibide. Bharat Chandra Das nalage. Nasiruddin, that is bracket respondent number 7, was teaching the subject of language. English was teaching the subject of English, while the petitioner was teaching the subject of Assamese. The respondent number 8, Azaruddin, respondent number 8, was teaching the subject of Hindi. So, accordingly, in the considered view of this court, in terms of the provisions of main provision of section 311, the services of Bharat Chandra Das was permissible to be so provincialized as a science oblique Hindi teacher, a science and mathematics teacher. The services of Zakir Hussain, Nasiruddin was permissible. The services of Zakir Hussain, bracket respondent number 9, was permissible to be so provincialized as social studies teacher, and the services of Nasiruddin, respondent number 7, who was teaching the language subject, was permissible to be provincialized against the language subject. Accordingly, the services of Bharat Chandra Das, Zakir Hussain, and Nasiruddin. Accordingly, the provincialization of services of Bharat Chandra Das, Zakir Hussain, and Nasiruddin is found to be in connoissance with the provisions of section 311 of the Act of 2017, and accordingly, the provincializations effected in respect of the said 3 teachers, including the respondent numbers 7 and 9, in the considered view of this court, would not mandate an interference. Referring back to the provisions of section 311, this court finds that a proviso incorporated thereto provides that for additional post provides that sanction of additional post in respect of an upper primary school shall be considered. Sanction for additional posts in an upper primary school shall be considered in accordance with the norms and standards stipulated in the schedule to section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009. This court finds that considering the enrollment status of students in the said school, the respondent authorities had sanctioned 2 further posts in addition to the 3 posts mandatorily required to be sanctioned, be created in a provincialized higher secondary school, to the said school. The issue now would arise is who is to be considered for appointment for provincialization, or who is to be considered for provincialization against the said 2 posts. This court finds that For provincialization of services against the said post, there would be 3 claimants left. That is, Aisha Siddiqui Begum, who was teaching the subject of Arabic, the petitioner, who was teaching the subject of Assamese, and Azaruddin, who was respond number 8, who was teaching the subject of Hindi. Mr. Abedin, learned counsel for the petitioner, had submitted that the subjects of Hindi and Arabic being compulsory subject, the teacher teaching the said subject is services of the teacher teaching the said subject in a venture educational institution is mandatorily required to be so provincialized. In support of his such submissions, he had referred to the guidelines laid down by the government for grant of recognition to a upper primary school, and therein the stipulation made of requiring 1 Hindi teacher. He has further referred to a communication dated 9/12/2019 issued by the Director of Elementary Education, wherein by projecting that Hindi is a compulsory subject in an upper primary school, along with the subject of Arabic, accordingly, there is a necessity to have a teacher have the services of the teacher teaching the said subject in a venture educational institution, provincialized as teacher/tutor, so as to ensure that the children studying therein are not deprived of the opportunity of learning the compulsory subjects. The said submissions have been made by Mr. Abedin has been duly noted by this court. On a perusal of on an examination of the provisions of the Act of 2000, on a close examination of the provisions of the Act of 2017, this court finds that the legislature had not made any provision in this connection, any provision requiring the provincialization of the services of a Hindi/Arabic teacher, a Hindi teacher in an upper primary school, and a Arabic teacher in a school which was earlier madrasa institute, which was earlier Middle English madrasa. This court finds that the provisions of the Act of 2017, more particularly the provisions of 311, does not make any stipulation in this connection. The schedule to the Act of 2017 with regard to the upper primary school only provides for a fixed salary that is to be paid to a tutor who teaches the Hindi subject / Arabic subject or language subject. The alternative subjects having been granted, this court would construe that once a language teacher has been appointed, there would be no further necessity for appointing a Hindi teacher / provincializing the services of a Hindi teacher or an Arabic teacher in this school. In the event adequate vacant posts are not available, adequate posts are not sanctioned, considering are not mandated to be sanctioned, considering the the enrollment status of students in the said school. Also, at best, the subject of Hindi and Arabic can be treated to be language subjects insofar as the upper primary school is so concerned, and it would be the senior most language teacher amongst the teachers teaching in the said school, whose services would be mandated to be so provincialized. Preferential treatment under the provisions of the Act of 2017 is not found to have been extended to a teacher teaching the subject Hindi and or Arabic in a venture educational institution for provincialization of their services. Having drawn the said conclusion, this court is now to consider as to the manner in which the two additional posts created in the said school is now to be so filled up. This court, on an examination of the provisions of the Act of 2017, is of the considered view that the said two posts is of the considered view that the requirement of main provision of 311 having been satisfied and services of 3 teachers teaching the subject spelled out therein having been done, the additional post now sanctioned would be so required to be filled up by considering the seniority of the teachers by reckoning their date of initial appointment. Applying the said principle to the facts of the present case, this court finds that Aisha Siddiqui Begum, who was appointed on 2/3/1995, was the senior most amongst the teachers, followed by the petitioner herein, who was so appointed on 28/8/2003. The respondent number 8 is found to have been appointed only on 29/5/2009. Accordingly, he is junior to that of Aisha Aisha Siddiqui Begum and the petitioner herein. Accordingly, the provincialization of the services of the petitioner of the respondent number 8, which has been admitted by the parties to the proceeding to have been so affected against the additional posts created beyond the mandatory post created for satisfaction of the main provision of section 311. Would not be maintainable inasmuch as his regularization was his provincialization of his services was so made, ignoring the case of his seniors, that is Aisha Siddiq Begum and the petitioner herein. Aisha Siddiq petitioner herein. Accordingly, in view of the above conclusions reached by this court holds that the provincialization of services of the respondent number 8 would mandate an interference. Accordingly, the provincialization of services of the respondent number 8 stands set aside. This court holds that against the additional posts so created, it is the services of Aisha Siddiq Begum and Jahana and the petitioner herein that would now be mandated to be so provincialized. The services of Aisha Siddiq Begum already having been provincialized, the same is not interfered with. Also, in view of the above discussions, this court directs the petitioner to submit a representation before the Director of Secondary Education Assam, along with a certified copy of this order, staking a claim for having her services provincialized. The Director of Secondary Education, Elementary Education Assam, on receipt of a certified copy of this order, shall place the case of the petitioner before the jurisdictional district level committee. The jurisdictional district level committee shall verify the service particulars of the petitioner strictly in accordance with the observations and directions made herein above by this court in the present order. On making the said on completion of the exercise of verification, the district Kutni committee shall submit its recommendations in the matter and forward the same to the Director of Secondary Education, who shall thereafter place the matter before the state level scrutiny committee. On the state level scrutiny committee completing the verification as mandated in the matter, shall submit its recommendation to the government, and the government thereafter shall proceed to pass appropriate orders basing on the recommendations now made in favor, now made by the constituted committees. So, in the event, upon verification of the service particulars of the petitioner, her case is found to have been recommended by the constituted committees, the services of the the orders towards services of the petitioner shall be so passed by the competent authority, and the provincialization of services of the petitioner shall be so effective with effect from 1/1/2021 as affected in respect of the other teachers whose services have been so provincialized in the said school with all consequential benefits. The exercise now required to be so conducted in terms of the directions passed here in above shall be initiated and concluded by the Director of Secondary Education, Assam, and the Secretary to the Government of Assam Department of School Education within a period of 3 months, 4 months? 3 months?
3 months, my lord.
3 months from the date of receipt of a certified copy of this order along with the representation petitioner. At this stage, this court would like to observe that the services of the respondent number 8, he is not getting any benefit till now.
No, my lord, she is getting.
Respondent number benefits of provincialization, the services of the provincialization of the services of respondent number 8 as tutor in the said school having been interfered with by this court, the respondents shall not recover the salary, salaries of fixed wages paid to the respondent number 8 as a tutor, inasmuch as he is found to have discharged his duties after such provincialization affected in his case as a tutor in this said school. With the above observations and directions, the present petition stands disposed of.
Obliged.
Deeply obliged.
Test it. Let's see what happens. Test it.
No, only thing is that in another case, I was asked to find whether the question of seniority, when the question of language teacher came in respect of Hindi teachers, when they were left, then this Honorable Court Coordinate Bench asked me to find out where is this sentence of seniority to be considered. But in 2017, unlike the 2011, the word seniority is again missing.
Missing, but how do you apply that? It can be, I like Jainal Abidin's face, he's a Hindi teacher, I'll give him.
I understood.
I don't like Jainal Abidin's face, I'll say, no, you're not a language teacher. So there has to be a yardstick. Maybe my yardstick is wrong, maybe a different yardstick, but it cannot be left open like that. It has to be.
I understand.
If you find something, come up with a review, I'll consider.
Okay. Deeply obliged.
Or there.
No, I'll go for R first. Deeply obliged.
Next case, huh? Yeah. Right, Raja. Yeah. Yes, what did you get, Mr.?
That's about from this record, I found that there are 2 orders of appointment order in respect of the respondent by 8.
The first one is 27/11/2004. And the second one is Lordship of 2010. 18/3/2010, page 159.
First order is page
Page 157. This was of 27/11/2004.
Nazrul Islam,
Nazrul Islam, response number Lordship.
157.
157.
And the next one?
Next one is of
158.
18/3/2010. Page number 159. So just while also on last occasion, I have submitted that there is a disputed question of facts involved with this petition. And the act itself is section 19. If there is some dispute is regarding claim for provincialization of the teaching staff, the matter should be referred to the tribunal Lordship. And this has been incorporated pursuant to the full bench.
Okay.
Decision.
We find in page 203, the respondents have already examined that matter. And they have come to a conclusion that Mojibur, you cannot be deemed to be senior to the respondent.
200.
So you have been provincialized, Mr.
Not
Goswami?
provincialized.
Not provincialized. I have been continuing as earlier.
Okay.
But in view of the
The
pendency of the
opposite-
case, Malad.
The dispute that you have raised, you go before the learned tribunal.
In the meantime, Lordship,
In the meantime,
order is that may be subject to outcome.
that would be subject to the.
That may be indicated.
Do it. Push up.
That's so far
Heard
the
Mr. A. Deka, learned counsel. for the
regarding the
petition.
appointment that let me record it.
That heard Mr. A. Deka, learned counsel for the petition. Also heard Ms. H. Taranpi, learned standing counsel, secondary education department. Also heard Mr. U.K. Goswami, learned counsel appearing for the respondent number 8. None has appeared for the respondent number 4 and 7, Miss M. Bhachaji. 4 M. Bhachaji. 2 port lagi mana? 1, 2, 3, H. Taranpi. H. Taranpi, respond number 1, 2, 3, 5, and 5. Miss M. Bhachaji, additional senior government advocate, respond number 4. None has appeared ever for some. And Mr. U.K. Goswami, learned counsel, appearing for the respondent number 8. None has appeared for the respondents number 6 and 7. As agreed to by the learned counsel for the parties, the present writ petition is taken up for disposal at the admission stage. Also, the petitioner, by way of instituting the present writ petition, has prayed for a direction of, has assailed an order dated 29/7/2004. Where is that?
Page 122, Lordship.
Page?
The impugned order. Impugned order is Lordship 203.
It was not brought in the writ petition.
No, is there, Lordship. Page note is, the writ petition.
29/7. I also got it there only.
But in the writ
29.
petition, that order
Wait,
is
there,
there, Malad.
page
Page
35.
34, Malad.
34.
Annex A.
30.
34.
Has assailed an order dated 29/7/2024, issued by the Director of Secondary Education, Assam, rejecting the claim of the petitioner to be senior to the respondent number 8 in BBSB High School, Borkhetri. Accordingly, the claim of the petitioner for being provincialized in his services
No, that's exercise yet to be done, Lordship.
was also not considered. Also, raising a grievance similar to the one raised in the present writ petition, both the petitioner as well as the respondent number 8 petitioner had the respondent number 8 had approached this court by way of instituting a writ petition being WPC number 8264/2019. The respondent number, the petitioner herein also had approached this court earlier by way of instituting a writ petition being WPC number 8872/2019. A coordinate bench of this court, while order dated 2/6/2022, consider the issues raised in the above noted two writ petitions analogously. Also, after considering the contentions raised by the parties to the proceeding, the coordinate bench of this court by the said order arrived at a conclusion that serious disputed question of fact was raised in the proceedings, and accordingly, it would be inappropriate for this court in exercising its writ jurisdiction under Article 226 of the Constitution to go into such question. Accordingly, the matter was remanded to the Director of Secondary Education to arrive at a factual determination with regard to the various claims made by the petitioner herein as well as the respondent number 8 herein with regard to the date of their initial engagement, which was disputed in the said proceedings. Accordingly, it was directed that the seniority amongst the petitioner as well as the respondent number 8 herein is to be so determined. Also, it is seen that in pursuance to the passing of the said order dated 26/2/2021, the Director of Secondary Education Assam, by order dated 31/2023, had opined that the respondent number, that the petitioner herein is senior to the respondent number 8. Also, however, after this something, nothing. Direct, then
No, after 31st of 2023's order, after the writ petition filed by the petitioner as well as by the respondent number 8. Because by this order, I was declared to be senior.
After this, what happened?
No, thereafter two writ petition filed.
Where do I get it?
That lordship will find the order of your lordship's order, page 122.
Also,
It
being
is
aggrieved by the said determination as made by the Director of Secondary Education Assam, by the order dated 31/2023, the respondent number 8 herein, page 120.
no, by 30th January 2023, this order issued by the director in favor of me by the petitioner. And against that, the lordship, the respondent number 8, he filed writ petition number 60/2024. Sorry, 62/4 of 2023.
The respondent number 8 herein approached this court assailing the same by way of instituting a writ petition being WPC number 634/2003. Also, the petitioner herein had also approached this court by way of instituting a writ petition being WPC number 4889/2023. Also, the said two writ petitions were taken up for consideration analogously by this court and wide order dated 86/2024.
Page 122.
By order dated 18/6/2024, proceeded to defer the consideration in the matter on being apprised that the Director of Secondary Education was considering the dispute with regard to the interstate seniority in the school between the petitioner and the respondent number 8 afresh. Also, this was then that order was passed.
No, yes, 29/7/2024.
Also, thereafter, the director of secondary education Assam, on a fresh consideration of the matter after providing for an opportunity of hearing to the petitioner as well as the respondent number 8 hearing, had passed the impugned order dated 29/7/2024. Accordingly, while order dated 7/8/2024, the writ petition being WPC number 6324/2023, both were disposed of,
As infractuous, Lordship.
and WPC number
Well, 100% submitted that is infractuous. Page
WPC
120.
number
There's order, Lordship, at page 127.
4889/2023 came to be closed as having become infractuous. The petitioner being aggrieved by the order dated 29/7/2024 passed by the Director of Secondary Education has instituted the present writ petition. Also, the Director of Secondary Education Assam, having basing on the materials coming on record during the hearing held by her in the matter, having concluded that both the respondent number 8 and the petitioner hearing were appointed in the school on 27/11/2004 and both had joined the school on 29/11/2004. Proceeded to determine the interstate seniority between the petitioner and respondent number 8 by reckoning the date of their respective date of birth. On reckoning the date of birth of the petitioner as well as the respondent number 8, the date of birth of the respondent number 8 being found to be 1/8/1974, while that of the petitioner being found to be 1/10/1974. The respondent number 8 was held to be senior to the petitioner herein. Also, the claim of the petitioner in the present writ petition is that, basing on the working certificates issued to him in the matter, he contends that he was working in the said school with effect from 1997. This court has perused the materials brought on record and finds that there was no formal appointment order issued to the petitioner while he for his engagement with effect from 1997. Thereafter, the petitioner is found to have been working against a leave vacancy. So, it is only on with effect from 27/11/2024, 2004, that the petitioner was appointed formally in the school in question, along with the respondent number 8. Accordingly, the determination as made in the matter by the director, by reckoning that the petitioner as well as the respondent number 8 had joined the school on the same date, by applying the by reckoning the date of birth of the petitioner and the respondent number 8, is not found to be erroneous by this court. Accordingly, the said order dated 29/7/2024 stands affirmed. In view of the above discussion, the present writ petition stands dismissed. However, it is provided that stands dismissed. However, there would be no order as to cost. Having drawn the said conclusion, this court, basing on the prayer made by Mr. A. Deka, learned counsel for the petitioner, provides that in the event it is so, provides that it would be open to the petitioner to approach the jurisdictional educational tribunal to establish his right of having been working in the school in question with effect from 1997.
It should be 98, Lord.
Huh?
Not 97, it's
98. With effect from 1998.
85,
Huh?
85,
88, 1998. What go 97. After being formally approved by the managing committee of the school for such engagement. Also, in the event of filing of any such proceeding before the jurisdictional educational tribunal, the jurisdictional educational tribunal shall consider the said appeal filed by the petitioner on its own merits, without being swayed by the conclusions reached either in the order dated 29/7/2024 by the Director of Secondary Education Assam and or in the present order. Also, the provincialization of the services of the respondent number 8 shall be subject to the final determination made in the matter by the jurisdictional committee. With the above with the above observations and directions, the present petition stands disposed. Affirm. The respondent number 2, the Director of Secondary Education Assam is now directed to process the matter for provincialization of the services of the petitioner herein. Such
Respond number 8.
Respond number 8. The Director of Secondary Education is directed to initiate steps for provincialization of the services of the respond number 8. So, the services of the orders, the said process as directed to be initiated, be concluded, and orders passed towards provincialization of the services of the petitioner within a period of 2 months from the date of receipt of a certified copy of this order. Tar pishot paki dismiss to khali say dibi only likit ha
Problem.
इससे मटा सारे साइट है yeah, it's right to Jato. Any urgent matter? Mr. Dhar?
My lord, I am waiting for the item number 4, madam.
Item number 4 I am taking up.
On 10/26 date will be given.
Or date she will give, don't worry. All dates will be given.
My lord, I was praying for item 36 and 37. Fortunately, this matter has been listed 4 times, but unfortunately never been listed, my lord.
Can't help it. After vacations. What is the issue?
So this is about gradation list, my lord. Juniors has been put above me.
You are Vishwakarma.
Yes, my lord.
Give me a facts.
My lord, here what has happened is I'm for the Assam.
Which department?
It is initially, right now, there is certain changes in the department. I am under the Assam Home Guard organization, my lord.
Home Guard.
Assam Industrial Security Force.
AIS.
AIS.
You were earlier the T thing.
Yes, I was in the T thing.
Then you came to AIS.
Yes, my lord.
Now what happened?
What has happened, my lord, once the Honorable Court has interfered, because in the year 2002, there was a judgment passed by the Honorable Court. Once I was in the ATPSF, the Honorable Court.
My Lord Justice Gogoi's order.
Yes, my lord. The Honorable Court said that now since I have been working there, and if the department wants me to continue, so either to give me a permanent status or rehabilitate.
Then they came up with AISF.
Yes.
6 months training and then appointment. You were appointed.
I was appointed.
Then?
But what happened is, like, once they made this cabinet meeting, after the cabinet meeting, they have formed this AISF. After formation of this AISF, they have brought me into contractual basis. Again, I approached before the Honorable Court. The Honorable Court says this: once you follow the judgment of the Honorable Court of 2002. So it means that you have to consider me from the initial date as to be a permanent status, since the post which was there was a permanent post. Accordingly, in the year 2008, my in the month of May 2008, my initial date of appointment was considered. Following that,
On contractual basis.
not contractual basis.
ATP, the T protection force.
No, my lord. Once they have formed this AISF battalion,
Your joining and contractual basis in AISF was treated as your initial date of appointment.
no, my lord.
Prior to that.
Once the this AISF was formed, the formation of the day of the AISF
Was treated
considered
as.
my-
Now, all joined on that day. What is the, how
Yes.
they differentiated
Now,
the?
the difference is, my lord, once what happened is like the group of people from AISF were absorbed in newly formed AISF from the ATPSF. Now, regular forces of the Home Guards were also there. They were brought up, who were holding various posts who were below the rank of mine. So what happened is those group of people were also being part of this regular force. Now, they have brought us into this force, and accordingly, we have given the permanent status. Since the execution of the matter was continuing, as a result of which there was a delay. Now, what happened is by then, there was various changes that took place within the department itself. Now, what happened is like in the year 2021, when the final gradation list of Subedar was issued, they have considered the fact that the whole scenario of 2002 to 2007, the
Okay,
cases.
Mr. Usama, I understand.
Yeah. And according to retrospective seniority was granted to me. But in the year 2023, the final gradation list which says that retrospective is granted, and accordingly my juniors, who were juniors at that point of time,
Promoted.
now we were in the same line. We were holding the same post. Now what has happened, like in the year 2023, those retrospective seniority, this criteria was mentioned in the draft gradation list, but all of a sudden in the final gradation list, this was erased. Meaning thereby, my lord, this due to the erase of this retrospective seniority,
You again come.
I have come down.
And your seniority position has now been again recasted.
Yes.
And is there a stand taken by the respondent that there was some complaint objections given? Because of that, they have taken a decision on for.
Yes, what they have said is like after filing of the writ petition, they have given us a reply to the representation which has been given by us.
What is the stand taken there?
The stand taken, my lord.
It's okay. Just.
The stand which has taken, my lord, what they're saying is like since my juniors, they were appointed first in the post of Subedar. That is the stand.
Okay. Heard Mr. K. Vishwakarma, Learned Counsel for the petitioner. Mr. Vishwakarma praised that there is an urgency in the matter and accordingly, the matter be listed on an early date. Also, considering the prayer of the Learned Counsel for the petitioner, 3637, registry to list this matter again on 21/7/2026. If I'm there, make a mention.
Yes, ma'am. My lord, there is an interim prayer.
Interim order passed earlier to continue till the next date of.
I'm obliged, my lord.
Lekha. WPC 1203/2008. Lekha. Hearing concluded. Registry to list this matter again. Birispati kita ase? No. Delivery of order. On Thursday for delivery of orders. Today, 5 minutes.
My lord, only item number 33, my lord.
Huh?
Item number 33, my lord.
33.
Yes, they are not receiving any salary. So it's some urgency, my lord.
When? Immediately after vacation?
No, my lord, prior to vacation.
As prayed for by the Learned Counsel for the petitioner, registry to list this matter again on 18, 6. Yes.
There are some matters, Lordship. Interims are there, I had item 28.
Give me 28, Likha. As agreed to by the Learned Council as agreed to by the parties, registry to list this matter
Yes,
again
Mr. DP.
after the ensuing vacation.
My last moment, I should be honest, man, it's a transfer matter. CGC, Mr. Chakraborty was there. He had said like before vacation, like after next Thursday.
क्या लिया? Put order एक दिया. Interim order to continue.
No, Malas, I agreed to that, no, so it will be unfair.
Sometimes Mr. Gogoi gets too fair, but that is not continued always.
Depends, Malas.
Yes, yes. Anything more? Any adjournment is there?
Mallet, may prefer item number 35 for fixing it, that mallet for hearing mallet. It's actually course has been decided by division bench of Delhi High Court mallet.
After vacations.
Else kindly before vacation mallet.
57 as agreed to. Huh? Then
Sir, item number 32, my lord, there is some urgency, my lord, due to interim order, my lord, press order 5 is out from service, my lord, so maybe not hardly.
What was the issue?
Issue, my lord, petitioner was appointed to discharge duties in the, my lord, girls' hostel. And subsequently
I
after
considered this, no.
one day, my lord, heard something, my lord, about this. Just
After vacations. Put out a video. A hearing, no? Pull out a video. Pull out a board using equus video. Yes. Anything more? There any no interim? Is there any
interim order is there.
interim order passed earlier to continue till the next date of list?
It was, my lord, earlier not continued, my lord, several orders was passed already.
This is hearing.
Yes.
Interim automatic. Yes, Mr.
Let's go to item number 38. Let's say I am put a respondent. Let's say may have the matter after vacation. They are prayer for upgradation from grade B to grade C. Their initial appointment as a grade B. After vacation.
As you have informed them, no? Due to paucity of time, the matter could not be taken up. Registry to list this matter immediately after the ensuing vacation. 38, 39 to माइडिवर 36, 37 to होई 35 एमसो क्या होई 33 होई 32 होई बाकी किता has agreed to এটা ডেট দি দিবা সব ঠিক আছে পিছত দিয়া যদি কোনবাই ৰিকুৱেষ্ট কৰে তেতিয়া আগত want a date take it from